is mentioning.
Question number page 1 adjustment. This number 1, page number 1. Serial number 1 to 5. Page number 2, serial number 6 to 14. Page number 3, serial number 15 to 22. Page number 4, serial number 23 to 31. Page number 5, serial number 32 to 41. Page number 6, serial number 31.
Yes.
This on behalf of this party, kindly next week, because the decree copy in that has to produce they are applied to get the
List this matter on 13, no further adjournments.
Right.
At the request of then counts for the petitioner. Yes.
Page number 6, serial number 42 to 48. Page number 7, serial number 49 to 53. Page number 8, serial number 54 to 58. Page number 9, serial number 59 to 65.
Please, madam, serial number 59, madam.
Oh.
I shall need further instructions in this matter regarding the payment of arrears. She has paid some, but the exact amount is not known.
It's on 19 to 2024. Why adjournment today? Order was on 19 to 2024.
Please, madam, I had
No,
contacted.
we'll see. When once the respondent comes, we will know. Please wait. Yes, next.
Please.
And for the respondent, there is another connected matter filed by your wife, my lords. Connect along with my lords and
Tomorrow, along with so and so, give the number. Along with so and so tomorrow, inform the other side counsel.
But I also filed a claim for withdrawal of amount, my lords. That was also not put up, my lords. Office may be direct.
What withdrawal of amount in a CP?
CPL, RPF.
You said 61.
61, my lords.
62.
62.
62.
62. List this matter tomorrow, it will come tomorrow. Give the number, list along with so and so, and inform the other side also. Yes.
Page number 10, serial number 66 to 81.
Serial number 67 on behalf of Chetan T. Limited. His daughter is not keeping well, hence he has had been to Bangalore yesterday night. 2 days time.
Yes. List this matter on, is 19th okay?
Please,
Does this matter on 19th, the request of one counsel respondent, interim order already granted is extended till that. Yes.
serial number 73. 73.
70?
73.
See,
2 weeks ago, to file objection.
no, like the same day, like in the other matter 19th,
Please.
at the request of one counsel the petition. Have you informed the other side? Anyway, you'll be here, let them come.
Serial number 73. Interim orders from family weeks.
Oh, well, now, all those matters, adjourned matters, if interim order is there, extend till the next date appears.
Serial number 78
Oh.
Your Lordship.
for the respondent.
Your Lordship.
Same, you are,
Your Lordship, the interim order has been passed in year of 2020, Your Lordship. Still, they have not paid any single rupee, Your Lordship.
which case?
78, Your Lordship.
78 is for the respondent.
And for the petitioner.
But then,
Your Lordship, may kindly have.
what the court can do? You are the petitioner here. Yes, same, on the same day. At the request of learned counsel respondent. Yes, next.
Serial number 18.
80,
18. Petitioner.
same order. Inform the other side.
Yes, already.
Yes.
Page number 11, serial number 82 to 91. Page number 12, serial number 92 to 99. Page number 13, 100. List number 1. Authorized, serial number 1. Suresh D.
Use the mic.
Please, my lords. This petition is filed challenging the order of the learned trial court, wherein, my lords, the respondent 1, 2, 3 file a suit for partition, three brothers. In the plaint, they say they have two sisters. One of them is the present petitioner. The sister files an pleading application. It comes to be allowed. She files a counterclaim. Thereafter, the plaintiff, respondent number 1, files a memo for withdrawal. The suit is permitted to be withdrawn. As far as the counterclaim, there is absolutely no order. In the meantime, my lords, respondent number 4 was the other sister who has expired, but LRs needs to be brought on record. I have filed an application. One of the LRs stays in UK, one is in Jalandhar. Happens to be.
So first of all, you have to pay the process. That's
Please,
not
please,
by.
please. Process. They have promised to send across the wakalat because it's the sister's sons and daughter. So they have promised to send.
So what is to be done?
Well, it's 2 weeks, my lord. So once the wakalat comes, I'll hand over.
I appeared for respondent number 1.
Respondent number 1 has expired.
Reported to them.
Expired and no LRs. He has died bachelor.
At the request of non-counsel for the petitioner, does this matter after 2 weeks? The needful shall be done.
Please. Great.
Why 2 weeks time? What are the office objections? CRP of 2022.
Advocate on record will be no more.
Huh?
That the other is no more.
Advocate on record is no more.
But the other is no more.
Finally, 2 weeks time is granted to comply with the office objection, or else the petition shall stand dismissed without further reference to the court. Yes.
We are going to seal number 3.
No representation. This matter tomorrow for dismissal.
Seal number 4. Second party.
2 days time. Counsel submits that they'll comply with the office objections within 2 days. If the objections are not complied, petition shall stand dismissed without further reference to the court. Yes, next.
Seal number 5.
For dismissal tomorrow, no representation.
Seal number 6. Article Kumar.
Permitted to comply.
Pass over. Petition is permitted to comply. Yes.
Seal number 7. Second party.
2 days only.
Same 2 days default.
Seal number 8. Dismissal.
No representation for dismissal tomorrow.
Seal number 9. Second party.
2 days time. Default order.
Seal number 10. Vijay Padali.
A week's time. Same in all the cases, time and the default order. Yes.
Seal number 11. Prashant Skardeva.
For dismissal tomorrow, no representation.
Seal number 4. Prashant Gorma.
Same order.
Seal number 13. Prashant Gorma.
Same order.
Seal number 14. DSND.
The Christian has collected more books and wakalat from me, and they want to engage some other advocates.
Can you file memo of retirement?
We have electoral papers and not with some wakalat who will work for advocate. I will issue notice to the party.
That's what issue notice and file a memo of retirement
2 weeks time.
at the request of non-counsel for the petitioner that it is submitted that he has given up wakalat. We'll come up with a memo of retirement. This is matter after 2 weeks. Give a date. Yes. After 2 weeks a date. Yes. Next.
Seal number 15. SC Raymond.
Same. No representation for dismissal.
Still number 7, still number 16.
I appear for the petitioner in this case. Dispensation of notice is filed for the R3 is not necessary party. And delay of 29 days in filing for I am for the petitioner.
A memo is filed.
Please.
Seeking dispensation of notice to respondent number
R3.
3. As liability is fixed on respondent number, something is written
Original, R1.
R1
R1 is the 20% contesting. Contesting is R1.
on the as such. Respondent number 3 is a formal party. The notice will be dispensed with. Notice to respondent number 3 is dispensed with at the risk of appellant. I number
2 is for delay.
I number 2 of 24 is filed to condone the delay of 29 days. Considering the reasons stated in the accompanying affidavit, the delay is condoned. List this matter for admission tomorrow.
And I am seeking stay in this.
Tomorrow we'll hear. And tomorrow both of you are here, will dispose of it.
Please. Records are necessary in this.
We'll see tomorrow.
Please.
Still number 17. Modification statement. Modification statement.
Which time is the sir? Control officer.
A week's time, default order. Next.
Please.
Please. Still number 18. A party.
Respondent has refused to take the notice, Manoj.
Argue.
It may be take notice to respondent maybe.
Yes.
No, this is a vice petition.
Docket order is notice to, as per the postal notice to respondent, returned as a refuse, amounts to due service of notice. Yes. From where you are seeking transfer? To which court?
From Koppal family court to, from Gadag family court to Koppal family court.
What is the distance?
Distance is around about 80 kilometers. 80 kilometers.
Any other case pending at Koppal?
No, madam. She is residing in the Malekapa village, madam. That is in the Koppal district, and she has to take 2 buses.
The present petition is filed seeking transfer of MC number 70 of 2024 pending on the file of the principal family court at Gadag to the court of the principal judge family court at Koppal. The brief facts of the case are: the marriage was organized on 15/10/2017 at Vidyadana Samiti Maidan, Gadag. It is a case of the wife that the respondent husband has thrown her out of the matrimonial home along with the children. She was forced to stay at her maternal. She is forced to stay at her parents' house at Mallekopa village of Kukanu Taluk, Koppal district, along with her 2 minor children. The respondent herein has filed MC number 70 of 2024 on the file of the principal family court Gadag seeking restitution of conjugal rights. It is stated that the distance between both the places is how much? 180. 180. Distance only 80.
80 madam.
The distance between both the places is 80 kilometers, and it's very difficult for her. She has to change 2 buses and reach the court, and it's difficult for her to travel, leaving with the children. The notice is served on the notice to the respondent as returned with an endorsement, refuse, and it amounts to the service of notice. Having read the land transfer the petitioner, there is entire material not recorded. Considering the fact that the wife is residing within the jurisdiction of the Koppal family court, and the distance between the 2 places is 80 kilometers, and she is staying in her parents' house along with the children. This court, considering the inconvenience being caused to the wife, deems it appropriate, pass the following. The so-and-so is withdrawn, and transferred to so-and-so, accordingly allowed. Next.
Seal number 9. Santosh Maliwal. Santosh Maliwal.
For dismissal tomorrow. No representation.
Seal number 20. Harish Naik. Harish Naik.
The within land council, the petitioner seeks 2 weeks time to pay the process. If the same is not paid within 2 weeks, without further reference to the court, the petition shall stand dismissed. Yes, next.
Seal number 21. Last notary. Last notary.
Weeks time for complying the office objections. Default order. Yes, next.
Seal number 22. Sajid Ahmed Purwala.
Kindly permit for the retirement.
Retirement memo. What about the retirement memo? What are the other documents?
But all documents have been handed over to me.
How the court will know? Some letter, something should be there.
Kindly pass over, ma'am. Kindly
Yes.
pass them around.
Pass over. Yes.
Petition was incremental instruments.
Notice to R1 is unclaimed.
Unclaimed.
Hmm. It's for the husband.
Yes, ma'am.
230.
230.
230. Pass over.
Please pass.
Yes. Yes.
24.
Only weeks time. Only weeks time.
A week's time. Same default order. Next.
Seal number 25. Similarly, Mantesh Level.
No representation for dismissal tomorrow.
Mantesh Level.
Weeks time.
Week's time. Week's time default order.
Seal number 26. Dharwad.
Needful is done. Like council submits the needful is done. Post after service of notice. Yes.
Seal number 27. RHLD.
One office objections were there. Remove the office objections.
Mhm.
I'll remove
The course of the-
In the meantime, all the matters people are trying to on the of this month. But since the petitioner has filed an application in 125 CRPC, so he seems he is disputing the paternity of children who are giving the maintenance against him. For the same reason, he filed an application to refer those two children for being examined. That was rejected by the trial court. That is the interim order which is challenged before the Supreme Court.
You comply with the objections during the course of the day. It will come up tomorrow.
There.
The petition is permitted to comply with the office objections. And if the office objections are cleared by tomorrow, this is matter day after tomorrow. Yes.
Seal number 28. Arunal Global.
Expert out on it.
Notice. History is directed to issue notice to respondents. Next.
Seal number 29.
Next matter also notice.
Next party. Issue notice. Seal number 80. SN Rajendra.
I filed this application, my lord, for extension of the time. My lord, while admitting the matter, my lord, when the matter will appear before this honorable court for admission, this honorable court was pleased to grant an interim order of stay, subject to deposit of 75,000 within 3 weeks.
When was the order?
Order was passed on 25/9/2024, my lord. And thereafter, my lord, 50,000 thereafter 3 weeks from payment of 75,000. My lord, the petitioner, I informed to the petitioner have sent a pleading, but they have put the pleading in the wrong name, saying that it is the Registrar General of High Court of Karnataka, bench at Dharwad. Actually, my lord, they ought to have paid quickly.
ED in the name of Additional Registrar General of the Court of Karnataka, Registered Dharwad. Therefore, my lord, there is time to be, my lord, party. It may take, my lord, another 2 weeks, my lord. You are asking the time to be extended. Time for payment, my lord, another 3 weeks, my lord. Because party is from Rajasthan.
This court by order dated 25/9/2024 had granted stay
Monthly
On the-
maintenance, so we are paying regular.
on the condition that we should deposit an amount of rupees 75,000 within a period of 3 weeks, and further a sum of rupees 50,000 within a period of 3 weeks thereafter. And we shall continue to pay maintenance at rate of rupees 6,000. In case of respondent number 1, 3,000 each in 2 respondent numbers 2 and 3 on or before 10th of each month beginning from October 2024. Where is the IA?
I was filed out 28.
IA3 of 2024 is paid. Please ensure that there is some silence in the call. Continuously people are talking. More than now. IA3 of 24 is filed for extension of time. It is stated that by mistake the deed is taken in the name of Registrar General instead of Additional Registrar General, and now again they have sent it back, and it would take some more time. Hence required some time. Considering the same, I number 3 of 24 is allowed by granting 3 weeks time from today. Yes. Yes.
For discussion, still number 31. Number 30, then our petitioner. What?
Husband, sir. Trial court has awarded rupees 7,000 to the wife and 3,000 rupees to the child.
By order dated 23/10/2023, this court had permitted the counsel for the petitioner to retire as he has intimated the client by letter dated 25/10/2023, and he has also filed a postal track consignment. Hence, this court has directed the registry to print the name of the petitioner. Having taken no objection from the present counsel, the petitioner has not engaged the counsel, not taken any steps to pursue the matter. In that view of the matter, the petition is dismissed for non-prosecution. Yes, next.
Bill number 32. Madan Mohan Kanu.
Minutes on the yesterday minutes, we have paid the PF minutes, but due to some confusion, we have only paid for respondent number 1 to 3. We can give course of day we will pay that.
Delete this matter from the caption dismissal. Let counsel submits that as far as respondent number 1 is concerned, process is paid. In respect of 2 and 3, in the course of the day, they will pay.
Please, respondent number 1 to 3, they have paid the PF minutes. Only respondent number 4 we have to pay.
Respondent 1, 2, 3, 4 during the course of the day. Say before that.
Please, ma'am.
List this matter after service of court. Yes.
Bill number 33. Harish Naik. Harish S. Naik. Mrs. Polio.
Withdrawal. Take the memo.
The respondents come back to the petition house and do it.
But the memo is filed stating that both the parties are living together, hence they were permitted to withdraw the petition. Accordingly, memo is taken on record and petition is dismissed as withdrawn. Yes, next.
Seal number 34. Adjourn. Seal number 35. Pallavi. Yes, Shana.
Password.
35 password. Seal number 36. New password. Another body.
Correspondent.
Password.
36 password. Seal number 37. Yeah,
That matter will have trial court disposed of. It may be not this.
When is it disposed of?
15/3/2024.
15/3.
2024.
Let counsel for the petitioner submits that the main MC itself is disposed of on 15/3/2024, and this petition has become infructuous, dismissed as infructuous. Yes, next.
Seal number 38. Then hunching money.
Not NC, criminal miscellaneous.
Criminal miscellaneous.
I appear for respondent.
Criminal miscellaneous. Yes. This is the RPFC of 2023. When the matter came up on 5/11/2024, as there was no representation on behalf of the petitioner, and the counsel for this court on 5/11/2024 had directed the matter to be listed in the caption dismissal on 6/7/2024. On the day that the counsel for the respondent is present. Today, when the matter is listed in the caption for dismissal, today also no representation for the petitioner and counsel for the respondent is present. It appears that the petitioner is not interested to pursue the matter. Accordingly, dismissed for non-prosecution.
Seal number 39. By corporation. Yes, and me.
I'm for the respondent.
Santosh Premi.
Give that. Right from 23/9/2024, there is no representation on behalf of the petitioner. The order sheet shows that on 23/9/2024, counsel for the respondent is present and no representation for the petitioner. Hence, the court has directed the matter to be released on 27/9/2024. Again, on 27/9/2024, none appeared for the petitioner and the counsel for the respondent is present. Directed the matter to be listed after Dasra vacation. And again, this matter came up before the court on 5/11/2024. Even on that day also, counsel for the respondent is present, no representation for the petitioner. Hence, the matter was directed to be listed under the caption for dismissal. Today also, there is no representation on behalf of the petitioner. The counsel for the respondent is present. It appears that the petitioner is not interested to pursue the matter. Accordingly, dismissed for non-prosecution. Yes.
Seal number 40. Petitioner support.
Just for petition.
Abhilash.
Seeking my lord transfer from my lord Billy to Gaza. But what happened, my lord? My criminal miscellaneous is my lord already disposed of. But in the very same court, my lord, DV Act is pending. My lord. This content of my lord permit my lord.
Just turn this.
No.
The CEO prayer.
Please. I have sought my lord transfer from my lord MC petition my lord 455.
So from Hubli to Gadar. As on that day, the criminal miscellaneous number is
And
pending.
he now it is disposed of.
Now, what is the distance between the two?
Lord, more than my lord 70 kilometers. After Gadar to my lord, she has to travel from another village. My lord. But same court, my lord.
Lord, according to my instructions, my lord, for her it takes 40 minutes. My lord. For me, it is 1 hour, my lord. And conveyance of buses from my place to her place is frequent, my lord. From her place to me, it will cause me hindrance. That is
Any
the
children?
No.
Children or the?
No.
And we tried for settling the matter also, my lord. They did not agree for our proposals, etc.
What is the MC? Divorce?
Yes, madam. It is for
Calculation is going on.
cross-examination. Now it is.
No, you don't want to join him and he filed a MC for divorce. Why you are not coming forward with any proposal?
Not personally contact the parties. 6 weeks.
Let the parties be present before the mediation center.
Please, madam, please, madam.
Once it is finished, madam, but I don't have objections for that.
Both the parties shall appear before the mediation center on 19th November.
Interim order for mediation.
The order earlier granted is extended till then.
Obliged.
Extended till the next date of hearing. Yes.
Bill number 41, Girish Sulman, he has already.
This matter came up on 5/11/2024 as there was no representation on behalf of the petitioner and the counsel respondent being present. Directed this matter to be listed in the caption for dismissal. Today also, counsel the petitioner is absent, counsel the respondent is present. The petition is dismissed for non-prosecution. Yes.
Bill number 42, Mankesha Siraman. Mankesha Siraman. 42.
Sum of rupees 40,000 is deposited before the honorable court. That may be
In which case?
before the section 41
Deposited by the petitioner.
by the petitioner.
And then you withdraw
Before that has been, it may be transferred to the Madras.
the amount that is deposited before this court shall be transferred to the trial court. Yes.
Bill number 42,
This is 42. It's court asked you to argue this matter. It's coming up for you failed to pay the process. Pass over. Yes. Pass over. Next.
42 pass. Bill number 43, Mankesh Siraman.
And the password, it has also become infectious, both the matters.
Yes, 44.
Please.
Bill number 44, Central Board, 14%.
ಇಂಗ್ಲಿಷ್ ಭಾಷೆ ನ್ಯೂನತೆ ಇದೆ ಕನ್ನಡದಲ್ಲಿ
English में submission नहीं कर सकते सर.
The party person submits that. You cannot submit in English. This is matter before the other court after obtaining the necessary orders from non chief justice. Yes, next.
Bill number 45, Sir Hegde.
May we permitted to serve hands-on to the because in the same address given at the trial court.
Petition is permitted to serve hand summons on the counsel appearing with the respondents before the trial court and should file a memo to that effect by 25th of November.
Please.
Yes.
Education matters, bill number 46, Suresh and Kini.
For the petitioner hearing. The petitioner lodge in earlier round of litigation had filed a suit for basic performance of agreement of sale in respect of the suit settled property. After contesting lodge, the matter came to be compromised. The terms of the compromise was there was another suit which was filed by some third party against the vendor. And pending that suit, my lords, this suit came to be compromised with some enhancement of rate and a timeline. There was exchange of notices. Wherein, my lords, it was specifically said in that other suit there is an order of injunction which is entered in the record of rights of the suit property. Hence, the sale deed could not have been registered. Ignoring all that, my lords, when this was sought for execution, the executing court holds, without any inquiry, without any evidence, that the compromise which has been entered has not been complied with the timeline, hence execution is not maintainable. First, I inadvertently had filed.
No. Suit for specific performance. Two suits for specific performance are pending. Isn't yours is one specific
Yes.
performance, there is another specific performance.
That was a suit for injunction or?
that was also a suit for specific purpose.
Then whatever is going to be the outcome of that, basing on that, this suit is compromised.
The vendor had undertaken, he will sort it out with the other suit of special
On that, a
purpose.
compromise is recorded.
On that, this suit is compromised. Not on that on promise of that, along with enhancement of rate. Wherein, my lord,
No, for example, this specific performance suit is decreed. The second specific performance suit is decreed. Then what would happen to this compromise?
precisely, my lord, that is why the vendor, who is also defendant in that suit, had promised that he is going to get that thing.
That is
settled
not
out
in
of
his
it.
hands.
But that was promised, my lord.
No, but how can such a compromise be recorded by the court?
That was done.
It's a kind of a decree which cannot be executed. Please come to the order.
Please do it. Now my brother says, my lord, here.
We'll explore.
Compromise.
Now, what has happened
No,
is
another compromise order will be passed by
not
this
another
court,
compromise,
which can never be executed.
what has happened is, my lord, by way of compromise, my lord, rate, my lord, to the property was increased from 45 lakhs to some, my lord, 1 crore and 36 lakhs.
No, forgetting about this compromise.
Yes.
What has happened to the other suit?
Other suit now, my lord, it is defeat. By virtue of, my lord, the plaintiff in this suit failing to honor the, my lord, terms of the compromise, I could not, my lord, satisfy the other one. He went on, my lord, on the merits. He didn't, my lord, honor the terms of the this compromise
The
petition.
suit is decreed now.
That is decreed. In fact, appeal is, my lord, filed by me again. It is pending, my lord, before quota number 2. It is coming up, my lord, in the hearing now. Now, my lord, after failing, my lord, to comply the terms of the, my lord, compromise, I gave a notice, my lord, requiring him to comply the terms of the compromise decree. He shots me a, my lord, reply notice, but didn't, my lord, comply. He was supposed to, my lord, pay entire 1 crore and some odd amount by February.
No, this is the result of a compromise which is basing on a future events.
No, that is not, my lord.
No, it is like he has to pay the amount on so and so date, on so and so. There is a compromise. How can there be a
No,
compromise?
not like that, my lord.
Let's
Your
look
lordship,
at it. Let's look at it.
compromise, my
There
lord,
is
terms may kindly see.
a page number.
15 is the order, my lord.
No, that
Compromise
compromise.
the decree. In fact, my lord, I am not served with the entire petition copy, my lord, along with the papers. Though I have, my lord, one compromise.
2019 case, and you are
And I am not complaining, my lord. I
not
have.
complaining. I'm saying that you are not having papers. Yes, let's see where is
Yes,
the
my lord,
compromise.
let him refer to the, my lord, page number, because I have got a copy of the, my lord, compromise decree.
Where is that?
Page 3 of, my lord, compromise.
Page 39. Lord.
The terms of the compromise are as under, my lord. Available.
Page number 41.
41. Yes. Married, my lord.
Yes.
The defendants agree and admit that they have executed a sale development agreement in writing in favor of plaintiff on 15/6/2009, agreeing to sell suit properties for the total consideration amount of 45 lakh 5,000. The plaintiff and defendants agree and admit that due to delay in completing the transaction, the difference stepped in between the plaintiff and defendants, which led to file the suit, original suit number so and so before this the very same. The plaintiff and defendants negotiated the matter with the intervention of the well-wishers, and the plaintiff agreed to enhance the total consideration amount payable to the defendants. And the agreement, the defendants also agreed to execute the sale deed by receiving the enhanced sale consideration amount. Number 4, the plaintiff and defendants agrees and admits that they have entered into a supplementary agreement of sale development agreement dated on 15/8/2012. Made further agreed to abide by the terms and conditions of the sale agreement of the sale development agreement entered into them separately on 15/6/2009. 5. The plaintiff shall, as per the terms of the agreement of sale or development agreement, pay and clear the entire amount on or before 28/2/2013 to the defendants without assigning any reason or cause.
What is this clause number 9? Please read clause number 9.
9. Yes.
Very strange that
some
court has passed
yes,
a kind of a compromise decree.
Since the agreement of sale executed in favor of Sri Tavanappa Patil, Ravi Tavanappa Patil is subsequent to the agreement of sale executed in favor of plaintiff, the defendant shall get the said matter in OS number so and so disposed, and in the event
if the advance amount of rupees 15 lakhs received from the said Ravi party is payable to him, the defendant shall pay the said amount to C. Ravi Karnataka.
No. Can you people compromise on a case
On behalf
which
of
is
the-
pending in
that-
some other court?
some,
And what is there in your hand? Matter is pending before the court. That's for the court to decide. And you want this to be executed.
This was sort of the executed, my lord. Page number,
Now let's please come to the order of, please come to the order of the court.
please, before that, my lord, for a moment, my lord, page number 59.
59.
59.
Mm.
This is the notice issued on behalf of the vendor, my lord, to the decree holder or the person who has.
No, I understood. No,
Please,
no
please.
notices to be looked into.
No.
Straight away come to the
Yes,
order.
I mean, thereafter, my lord, next page, sorry for the inconvenience, next page 61.
Mm.
This is the reply given, my lord. This is the reply given.
Yes.
But all these things have not been inquired into by the learned trial court. Lord. The learned trial court holds, since within this time period you had to give, you had to.
Now the fact remains is that suit is decreed.
I was not, I don't.
That is subsequently, not subsequently.
Subsequently decreed. Let it be. First of all, how can there be a compromise like this? Very strange. You cannot compromise somebody's suit where you are not a party,
I'm not.
and how the court will decide which it has no jurisdiction to do it. When you don't know what is the outcome of that suit. What is just because he wants to withdraw or he wants to negotiate, is it that it is going to materialize? And basing on a future some unsuccessful or successful event, how can there be a compromise? And how is it an executable decree?
Contingent event, my lord, on the basis of a contingent event, turns very.
And then on the promise that yes, he is going to get the matter settled.
Court should have, which court is this? When is this order passed?
That was, my lord, the compromise decree was in the year 2012.
12.
17/8/2012. And this decree, my lord, he seeks execution in 2017. That is dismissed, my lord, in 2018. He approaches this on court, my lord, in 2020. So diligent person, my lord, to have the agreement executed through the
It should have
process
been
of.
something like you could have included yourself in that suit where that specific performances, even before that, he has executed an agreement of sale. Or there would have been something else. How can this be executed? You will not get any relief. The court was right. Maybe the reasoning given by the court is not right, but ultimately the result is right. You cannot seek for enforcement.
Because at least there is no loss of forfeiture for refund, at least the export. Around 40.
As per the terms of the compromise decree, I will have to forfeit 50% of the advance amount and return 50% of
Then
the.
what about the return amount?
No, that has been not observed by the even executive court also. What
That is entitled for that. Where is that order? Let's see.
Yes, yes. Page, I don't have. Paragraph number 19, my lord, of the executive court order.
Please read.
Page number 27, para number 19. As per the compromise decree and supplementary agreement, 5 was the absence of agreement and contract. Though the supplementary agreement dated so and so is continuation of the original agreement dated so and so. As per compromise decree, the transaction between the parties can cancel in the event of non-compliance of the terms of the decree and supplementary agreement. The defendants have to refund half of the amount of the plaintiff decree holder received from him and retain remaining half towards the damages for non-compliance of the terms of the payment of amount by the plaintiff.
Paragraph 23. As per condition number 7 of compromise decree, the judgment debtor shall refund half amount of the total amount received by them to the decree holder and retain half of the amount with them towards damages for non-compliance of the terms of the compromise decree as well as supplementary agreement. The decree holder himself has not complied with the terms of the.
No, where is the executing court observed that he can have that 50% amount?
That is not forthcoming at all.
As per the condition number 7, the judgment debtor shall refund half of the total amount received by them, retain the amount.
and retain half of the amount with them towards the damages.
Then do it, we'll order that, they
That,
will.
that is undisputed.
Then pay it. That will, I think,
That,
to that extent we'll allow this. What is that?
Lots, I was,
First of all, if legally to be seen, you are not entitled for anything. But anyhow, if the best what that could be done is that 50% of the amount you will get.
without prejudice to the deposit of the amount which the judgment debtor may do. Liberty may also be given to include himself in the RFA 1.1.
No. In a revision, what is this granting liberties and all?
Or
Arising out of an
may I
execution
request-
petition.
Please, may I request, Lord? The notice the reply notice at page 61, which specifically says, my Lord, so because of the order of injunction, the decree holder could not get the compromise decree executed and sale deed registered. This has not been looked into at all. No inquiry has been done upon this. This is a document which is before this court for the first time. Let the trial court, learned executing court, hold an inquiry at least.
And
to
what
bring
the
forth
court
fact-
should do then?
Bring forth the fact, my Lord, because it is not the
What is execution you are seeking? You are seeking execution of a sale deed.
compromise decree. Yes.
Sale deed.
Yes.
Is it possible?
Lord, that execution would be subject to the result of the first appeal where the vendor himself has challenged the decree.
So what is to be done now?
So subject-
This order has to be confirmed. What do you want the court to do?
Lord, my only
There cannot be a sale deed executed in your favor because there is a decree staring at your vendor.
Lord, my way would have been, Lord, the matter to be remanded back for inquiry.
What inquiry?
That is what, Lord, the facts of which have
No,
not.
what inquiry to be done?
The executing court might as well conduct an inquiry.
Let's
Lord.
assume that the inquiry is done. Then what the court should do? Court should ask him to execute a sale deed in your favor.
Lord,
First of all, that is an inexecutable decree. You, unfortunately, are a part of it. So, better you withdraw this petition, or it has to be confirmed the order, or we can clarify as far as the 50% is concerned. Sale deed you cannot. You are not entitled for a execution of a sale deed.
please. As far as refund may be concerned,
Huh?
refund of
That amount. Please come. Agreed with the orders passed in execution case number 79 of 2017 dated 7th June 2018. The petitioner, who was the plaintiff in the suit, is before this court. The petitioner herein has filed a suit for specific performance. The said suit came to be compromised. By the time the said suit came to be compromised, the defendant has already executed an agreement in favor of another party, and that party had instituted a suit for specific performance, which was pending consideration. Then, as per the terms of the compromise entered into between the parties, dated
17th August 2012.
17th August
2012.
17th August
2012.
2012. And as per the said compromise, As per clause number 7 of the said compromise, memo of compromise, the plaintiff and the defendant agrees and admits that in the event of non-compliance with the terms of the compromise application and the supplementary agreement of sale oblique development agreement and cancellation of the sale deed referred, the defendant shall refund half of the total amount received by him to the plaintiff and retain half of the total amount received by him towards damages for non-compliance of the terms of payment of amount by the plaintiff. And by virtue of this compromise, the plaintiff has to pay the amount on or before 28/2/2013 to the defendant without assigning any reason or cause. Full stop. As per clause number 9 reads thus. Extract clause number 9 at page number 42. Thereafter, the present execution petition came to be filed. It is a case of the defendant, the plaintiff that it's a case of the defendant that as the plaintiff has not paid the amount and as a time is the essence of the contract, he could not compromise the matter with the plaintiff in the other suit, and the suit came to be decreed. It is the case of the plaintiff that. What is that page number 59?
59 is a notice issued on behalf of the vendor to the decree holder, my lord.
It is stated that
that you have not complied.
the vendor issued by the vendor to
Please.
on 13/12/2013, a notice is issued by the vendor to the by the defendant to the plaintiff, and a reply was given on 7 January 2014. And without 14, it is a case of the plaintiff that the decree holder that the trial court, the executing court, without considering that there are laches on the part of the vendor has dismissed the application. It is the court had failed to order the execution petition when the defendant had taken all the amounts from the plaintiff, and he has to execute the sale deed. And when he fails to execute the sale deed, the court should have ordered the same. When counsel submits that, even as per the terms and conditions of as per clause number 7 or 9 it is.
Nice.
As per clause number 9, even if there is no compliance, if there is even if there are laches on the part of the plaintiff, still he is entitled for he is entitled for 50% of the amount. Even that aspect was also not considered by the court. Next one, learned counsel appearing for the judgment that our defendant submits that the suit which is filed, which is mentioned at clause number 9. No. Earlier clause is 7. That is 7, this is 9. As per the clause number 9, I was referring to clause number 7 about refund of the money. Clause number 9, as per clause number 9, the suit that is mentioned, that is OS number 72 of 2011, is already decreed, and the judgment that our defendant herein had already filed an appeal against it. That is MFA number.
That is RFA number, my lord, I shall furnish you.
RFA number, not necessary. He has filed an appeal. He has filed an appeal before this court, and the same is pending consideration. He submits that as per the terms and conditions of the compromise memo, the decree holder has failed to pay the amount as he has failed to pay the amount within the time, he couldn't negotiate with the plaintiff in the other suit. And in the process, the said suit is decreed, and he is not entitled for any, is not entitled for any, the decree cannot be executed, and the executing court had rightly dismissed the petition. Next, for having heard the counsels on either side, peruse the entire material on record. A perusal of the order impugned the court has observed that as per condition number 7 of the compromise decree, the judgment debtor shall refund half of the total amount received by them to the decree holder and retain half of the amount with them towards damages for non-compliance of terms of the compromise decree as well as supplementary agreement. The decree holder himself has not complied with the terms of the supplementary agreement within the stipulated period. Hence, on the strength of the compromise decree, the decree holder cannot insist the court to direct the judgment debtor to execute the registered sale deed in his favor. Accordingly, the court has come to the conclusion that the execution petition is not maintainable and accordingly dismissed the same. The manner in which the compromise is entered is unknown to law. In the compromise decree, they have entered into a compromise basing on assuming or presuming the outcome of a suit to which plaintiff is not a party. And when the matter is pending before the court, what would be the result of the said suit cannot be assumed or presumed, and basing on that, a compromise cannot be entered into. Leaving all these things apart, even as per the judgment debtor and even as per the trial court, even if in case is any violations of the terms and conditions of the compromise, still the judgment debtor is entitled for 50% of the amount which he is paid. There is no dispute on that. Even the court in the order has observed. In such case, the court at least ought to have ordered the execution as far as the 50% of the amount is concerned. But however, as the decree holder is asking for execution of the sale deed, the court had dismissed it. The execution of the sale deed is not possible as there is a decree in favor of the decree is passed by a competent court directing the defendant judgment debtor to execute the sale deed in favor of the plaintiff therein. In that view of the matter, this court deems it appropriate to modify the order passed by the executing court, and the judgment debtor is entitled for the 50% of the refund of the amount as per the compromise.
Advance.
50% of the amount as mentioned in the compromise.
Compromise.
Execution petition decree holder.
Decree holder as mentioned in the compromise decree. Accordingly, disposed of.
Please.
Interestingly, my lord, an application was moved by the defendant himself for recalling this compromise decree. That was, my lord, rejected, and later, my lord, he came to the
All things which are unknown to law are happening. Yes.
Great.
Number 47, you have read
That was the petition. That's the husband's revision petition. Must the order passed under section 127 of CRPC for enhancement of the minority maintenance. Despite the fact.
How much was the initial maintenance granted?
Earlier, before this, earlier to this, the wife and children has filed a petition under section 125 of CRPC before the trial court. That before the trial court, some amount was awarded. against which, my lords, the petitioner herein has approached this honorable court. That is at page number, my lords.
So how much is granted?
Now it is 12,000 granted globally to the,
All the three?
no, all the two, my lords. Son is major.
Two. Then what is the enhancement they are seeking now?
My lords, earlier to this, my lords, the criminal petition was filed by this petitioner, that is at page number, my lords, 19. Earlier petition was, my lords, they have filed, my lords, criminal misdemeanor petition number 22/2023 before the, my lords, Learned Family Court at Ballari. My lords, sum of rupees 5,000 is awarded to the, was awarded to the, my lords, wife, and 3,000 each to the children at that time.
11,000.
3,000 is, my lords, 6 plus 11,000. My lords, against which the petitioner herein has filed, my lords, RPFC in the revision in RPFC number 1000105 of 2014 before this honorable court. Before this honorable court, my lords, can see in page number 19. In that, my lords, the more particularly, my lords, page number, internal page number 7, running page number 25. My lords, last, my lords, 8 lines from below. Exhibits R1 to R13. My lords, exhibit R1, R11 to R13 shows that the first respondent is trained in tailoring. In fact, the first respondent has stated that she is doing tailoring
So
work.
it has been reduced from 5,000 to 2,500.
2,500. my lords.
And for the other two, it has been reduced from 3,000 to 2,750.
But despite this fact, she filed another petition under section 127 of CRPC, saying
No,
that
this order is when?
that order
This
is
is on 15/10/2018.
please, ma'am.
And when is the 127 petition?
That is 127.
When?
That is in the year 2018, my lords. Page number 9.
No, your RPFC is disposed of
Please, ma'am.
on 9th
On 9th of September
14.
2014.
14.
Again, she filed a, my lords, criminal misdemeanor number 293 for 2018, in the year 2018, wherein, my lords, the Learned Family Court has awarded globally rupees, my lords, 12,000.
Now it is for 2 or 3?
For 2 only, my lords.
For 2.
For son, it is not awarded.
So it's 6 and 6.
Yes.
So from 2,500 to, it has become 6, from 2,750 to 6.
Yes. My contention before Lordship is, my lords, our main contention to decide separately is that since the husband was not taking care of that, he was harassing. And in that connection, she has also filed a, my lords, criminal case. That is the one, my lords, I filed application for additional documents. Wherein, my lords, she has filed a, my lords, case against the husband, mother, and the married sisters also. And the married sisters have approached the honorable court, principal bench at renewal. That petition came to be allowed, in page number 19 in my petition.
Yes.
And before the trial court, she, my lords, she has result from her version, my lords, the petitioner came to be acquitted. The only ground which she is, even the, my lords, mediation report is there before my lordships. The only ground she is urging is, my lords, the husband was not taking care of it. But if that is the case, my lords, she would have supported before the, my lords, the trial court while conducting the trial. Hence, my lords, she is not entitled for any maintenance. Children are, my lords, always entitled. Wife is not entitled because she is also doing the tailoring work as per the exhibit R11 to R13, which is marked.
So divorce is not granted.
Divorce is not granted.
Nobody filed.
And it is pending.
Husband has filed. That is dismissed. Husband has filed a divorce petition that came to be dismissed. And against which, my lords, I filed the appeal before the honorable court. That is pending. That is in, my lords,
On what ground you find the divorce?
filed for harassment and also on desertion, for cruelty and desertion.
So court held that there is no desertion.
There is no desertion. She was resigning.
So now the only aspect that has to be looked into is what is the income of the wife? Nothing else.
As per the Marat's exhibit 311 and 311 to 13 in the earlier proceedings, she has admitted that she is a trained tailoring.
What is your income?
Income is, as per the bank statements of the petitioner, in the year 2021, it is 33,204.
33,000
204.
is your salary.
Yes.
Oh. How much the court has awarded? Well, for both of them.
12,000.
Why it is on the higher side?
My only contention for children are entitled. Now son has become a major, he is not entitled.
No, when you say that wife is not entitled, you should be able to show that there is she is having sufficient
Criminal case
income.
which she has filed, and she has resigned, and she has been treated as a malad hostile witnesses, and the honorable acquittal has been given to the malad.
No, any acquittal in a criminal case doesn't mean that she is not entitled for.
Well, her version in the before the trial court in the criminal case, that the reason for she staying away from Malad's child care to Ballari is saying that husband was harassing her, and she filed a Malad's
No, if you are not harassing her, according under 125, why under what circumstances the wife is not entitled for maintenance?
Malad, she is willfully residing separately without
No,
any task.
in that case, when you have filed a MC on the ground of desertion, court had dismissed it.
Yes.
So what does it mean? That the desertion factor is not established. So for 125 on that ground, we cannot non-suit her. Now, the only aspect which you have to tell the court is whether what is her income and why she doesn't require maintenance. Now, whether that whatever she is earning through trading, is it sufficient for her to live her life?
She is working as a Malad, she is doing the tailoring work.
How much is earning? That's also an aspect.
Malad, the acquittal on Malad 6.
So what we'll do is, please come to the impugned order, how the court has dealt with her.
Acquittal was in the 2023, Malad.
No, we'll look at the criminal miscellaneous order.
Yes. Reasons on point number 1. May I read from that? In proof of the petition argument wherein the petitioner one has specifically created in page number 1, para number 1 to 3 about previous orders of maintenance, and same is modified by the Honorable High Court of Karnataka and so on, so in Dharwad bench. The petition number 1 has given the particulars about her expenses and need of money as per the present legislation in page number 2, para number 3 to 7. In page number 3, petition number 1 has specifically created for enhancement of maintenance to the sum of rupees 25,000. In response, respondent has specifically denied the petition argument at the first instance. Later, he deposes, he is submitting in page number 2, para number 5 about the previous litigation and what led for the disturbances in the family, and he is working as a teacher and residing at Cherry town. The respondent submits in criminal miscellaneous so and so about the award and the modification of the same in page number 3 of his counter. The respondent has specifically created in page number 3 about his residence and travel to workplace, and he is regularly paying the maintenance. Further, he specifically needs and petitioner is capable of maintaining herself as he is earning more than 10,000 per month by doing tailoring work, as such 6 dismissal of the petition. At trial, petitioner number 1, in her evidence before the court, has specifically deposed in para number 1 to 3 about her previous case and the maintenance ordered and modified by him. She specifically deposes in page number 2 and 3 about the need of money for the higher education of her children, and she needs approximately about 25,000 to 30,000 for the college fees, books, other incidental expenses. In page number 2, para number 4 and 5, she declares about her son suffering injury while moving on a bicycle to school and incurred expenses to the tune of 30,000. In the year 2013, her husband's salary was 35,000 per month. Now it is increased to 50,000 per month. As such, she seeks the enhancement of maintenance, In her cross-examination data so on. So she admits about the previous litigation and order passed by hearing by this court and also Honorable High Court of Karnataka. In page number 4, para number 9 and 10, and even in page number 5, para number 11 and 12, she deposes specifically about her need for money for the school and college education of her children. But she pleads ignorance about the order of the Honorable High Court of that maintenance to the children is awarded only up to the majority. She has produced the rent agreement which has been admitted to be a copy. She denies the suggestion that she is paying the same amount of school fees and college fees as of the year 2015 to 17. She has specifically denies the other suggestions. She proposes her children have to move in a bus to school about 6 to 7 kilometers and denies the other suggestions made by the learned counsel for the respondent. She specifically denies in page number 6, para number 16, about her earnings of rupees 10,000 per month from tailoring work. She has further placed a school receipt of around exhibit 330 and 31. In response, the respondent got examined himself as RW1 and deposes in consonance with the contention raised in the counter. He specifically submits that his monthly rent increased from 5,000 to 10,000 in childcare. However, he has placed medical documents to show he has suffered accident and had undergone surgery and is not fit as before. As such, he is unable to make arrangements with regard to the claim of the petitioner.
Even with that 12,000, even if she is earning, it's very difficult for them to live. And you are having income, why do you deny that?
I'm earning, with respect of children, I have no any objection.
So even children.
In year 2013, she has separated from the university petition.
So no, the court had granted 3,500, 3,500.
Yes.
And apart that, you also admitted that they are living in a rented premises. The premises, they have to pay around 5,000. So with 3,500, do you think that the needs of the children can be taken care of?
Mediation report is there for our lordship. In that mediation also, she blatantly denied to join with the company of the petition.
Because of a harassment, Your Lordship.
My lords, since
My brother
2013,
counsel complete his hearing.
No, if he is harassing and you don't want to join him, then why can't why do you oppose the petition for divorce?
Lordship, she wants the status of the wife because she has to conduct the marriage of both the children, Your Lordship. So once if she is gazetted, Your Lordship, once if it is held that she is a divorced wife, the status of wife will go. So that is the reason what she has stated before the mediation center, Your Lordship. I very well know it cannot be relied upon, but still then, Your Lordship. She was very much willing to join her husband, but the way how he approached her was very.
No, from how long? It's been right from 2013, we are in 2024. Even till now, from the last 11 years, it's all going on. Forever you won't join him, nor you're ready for the divorce, and forever you want maintenance. How can it be?
Lordship, it is for the children, for sake of children, Your Lordship. May I draw your attention towards the additional documents which has been produced by the other side, Your Lordship, wherein she clearly turned the postile stating that for the reason of a marriage of the children, for the future of
No,
the
let's
children.
forget about the criminal case.
Please.
Let's forget about the criminal case, but it can't go on forever. That you will not give him divorce, you will not join him, and forever you will continue this. How is it possible?
With regard to divorce petition, Your Lordship, I have not discussed with her, Your Lordship. I'm very clear.
No, let her come out with the settlement. No, she doesn't want to join him, and according to her, he is doing all.
One thing, husband says that he wants her to join, but now his mother is also no more, Your Lordship.
Who is no more?
His mother. Thus the mother-in-law of the wife is. The respondent is no more.
The mother was staying with the minority petition. That is
It is
now
not the reason.
she is also no more. If she comes and joins, I am ready to take her.
One thing is that.
My lord, can we see the mediation report? Mediation report is there.
Mediation report is before your mother or after your mother expired?
After expiry of mother.
Then what did she say? Even that also
She has refused to join. That is the
For the
report is
reason,
there.
for the reason
Report is
that
kept in
he
the
started
file.
harassing her there and she was crying, Your Lordship. I'm not.
No, that's true. Then if that's the case, if things are not
He
going all
specifically makes
right.
an allegation with regard to her some illicit relationship like that. He will talk with someone like that. For that reason only she is refused to join, and she herself is maintaining the children, Your Lordship. Now one though that she is staying under the paying of IAS, Your Lordship. He never paid for her till this time, Your Lordship. One that son is doing MSc and the girl is doing staying at Maharani's College, Your Lordship. I'm having the documents. But in review petition, we cannot put the additional documents. That's why I kept it with a memo, Your Lordship. So he never cared for her. At this stage, now when the mother is no more, no one is to look after him. Now his leg is fractured. He wants her to come and serve him.
So you don't want to serve him, but you want maintenance from him.
Lordship, for that one, nothing more is awarded, Your Lordship. It is his responsibility. Now he gladly refuses to refuse her.
This responsibility, how long it continues? For 20 years, 10 years, like that?
But he is ready. If all the respect, your lordship, if she was ready.
Then she should try for that. Without even trying, without even making an effort. You just can't have the best of
She
both the
was in the
worlds.
mediation center, your lordship. She was there, she.
Ask them to appear before the court, Mrs. Mata,
Please, your
on,
lordship. Please.
on 26th November. But both the parties shall appear before the court. Any matter is there on that day.
26.
No. 26th at 2 o'clock.
Please, your lordship.
The list has come in that. List.
Lordship.
Yes, next one.
With lordship give permission, I'll file a memo along with the documents with regard to the studies of children.
Not required. They are not required for this.
Because he never cared for the children, your lordship.
Some matter is there. Then let it be on 27th.
Please. Oblige.
Yes, next.
Seal number 48.
Last occasion, and learned senior friend took time to produce an agreement before this.
Oh, that's a
tender matter.
And
it appears that learned senior has filed the tender copy, but he has not served me. Even I have already won that case. Court has given it. It's okay, Manas. I'll collect another copy from him and I'll submit it.
Is this matter tomorrow?
Tomorrow.
At the request of Land comes for the petition tomorrow. Yes, next.
Seal number 49. 8 party. Withdrawal.
Give the file.
8 party.
There no representation for the petitioner. This is matter tomorrow for dismissal. Counsel for the respondent is present. Yes, next.
Seal number 50. Number 34.
Yes, Commissioner.
Is it heard before?
Please.
Is it heard before?
No.
Yes.
Petitioner is the purchaser of lands number 8/3 Missouri, 5 acres out of 7 acres 13 quintas.
Now, what is this? What is the site?
The order under challenge, my lord, is trial court has treated the issue number 6 as a preliminary issue. That, my lord, with regard to the pecuniary jurisdiction of the trial court, suit is undervalued is one of the issues that has been framed. Trial court holds that, my lord, it is valued property value. That is the finding of the trial court, my lord. Without considering, my lord, the exhibit P 41 and 42, which I have produced.
So, what is the suit for? Suit for declaration.
Suit for, my lord, partition.
Partition.
Separate possession. Earlier to that, my lord, the kindly see, my lord,
You are the member of the joint family. You are a purchaser from the joint family members.
yes, joint family property, my lord. That is, the lordship kindly for a moment, page 63 may kindly see him where you lordship get the journalist. I purchased from defender one Ramesh.
60?
3 minutes. Plain copy which I have produced. I purchased it from Ramesh. That original property to Lakshman Ramappa.
Who is the plaintiff?
Plaintiff is the daughter of this Ramesh.
Lakshmi.
That Aishwarya.
Aishwarya is.
Lakshmi is the wife. And Aishwarya is not even born when I purchased the property.
She's not even born.
Not even born. I purchased it on 15/5/2010.
15/5.
2010. She born 15/5/2010. I have purchased it. 5 acres. She born on 13/11/2011. Even it cannot be considered as a child in the womb. That is also there. And earlier to that, what has happened? You will just kindly see this Irava, defendant number 4, which you also can find in the genealogy. Irava, this page 63 genealogy.
What is the name you said?
Irava, defendant number 4.
Irapa.
Yes, ma'am. She filed the suit OS 149 of 2012. On 20th September 2012.
20th September.
2012.
Huh.
Against all the suits of property which are subject matter in the present suit. She filed a suit for partition. And I have purchased 2010. That purchased property is allotted to my vendor and it is allotted to my share in the equitable partition. FDP is filed, FDP is pending. Now commission is appointed and served the property. Now it is in the verge of drawing the final decree. At this stage, she has filed this suit, including all the suit scheduled properties which are subject matter in the earlier suit, that OS 149 of 12. And RFA was filed before this round report. RFA was dismissed. By 2 RFA was filed, both are dismissed. She filed the suit, including all the.
No, she filed RFA against that preliminary decree.
No, yes, ma'am. Preliminary decree in OS 149 of 2012.
That was dismissed.
That was dismissed. But 2 RFA was filed. I have filed and another person has filed.
But why you should give that is given to the share of you were not a party.
No, I was a party.
In the original suit,
Yes,
you were a party.
I was a party in OS 149.
So there must be a finding that because you purchased the property from the defendant, whatever that falls to
Yes.
share, you are entitled.
But however, that is may not be a subject now. But RFA.
No, may not be a subject,
Yes.
but for the better understanding of the facts.
Yes.
No, what was the finding?
The
In
finding.
that OS for 149 of 2012,
Yes.
you were a defendant.
Yes.
You are the purchaser.
Yes, I
What
fully-
is the finding of the court with regard to your purchase and your title, your
No,
right?
I have purchased and share that has been my vendor is.
Will come to your share. That's the
Yes.
finding.
Yes.
In that case, why did you file an RFA? That's what I'm asking.
No, I don't know, madam. I have not filed the earlier
Yes.
proceedings.
That
And-
that your RFA is dismissed and now that's in the final decree.
Yes, that fine, decree become final and the FDP is filed and this 20th mother,
No, in this suit, she do not mention about that earlier suit.
she mentioned.
Then what should happen to the decree? She asked that the decree is not binding on her.
No. That is not asked me. Kindly see the prayer 69.
Doctor claims that earlier 1/4 share was allotted to my father. So I have filed suit for partition 1/4, half of 1/4 share. I thought.
She is only concerned with.
Yes, to the share of my father.
Then how is he? Father is Ramesh, from whom only she.
Yes. That is my suit.
Understood. Yes.
She filed a suit, not the earlier properties is
Will just
mentioned
please come to the prayer. Come to the prayer.
in the present case.
The plaintiff may kindly be awarded half share in the 1/4 share of defendant number 1 in all the suits schedule AB property. AB properties are which are already partitioned.
Yes.
Please.
Uh,
I am claiming in my father's share.
Nothing else.
Nothing else. Yes.
It may kindly be declared that the sale deed executed by defendant number 1 in favor of defendant number 5 and 6 dated 14/5/2010 are not binding on the share of the plaintiff minor in any manner. There is no existence as on that day. On the date of sale deed, her existence on this earth is not there.
So, my lord, sir, can you see preliminary issue was framed with regard to, so he is challenging preliminary issue. My lords may kindly see order at page number, my lords, 13. It is his contention that my suit is undervalued.
That's the only contention you have raised.
Yes,
Nothing else.
yes, that is the issue because we can't go beyond the issue.
No, according to you, because it is she valued it under section. Suit is valued under
35(2) months
35(2).
and also 24D.
According to you, it is not in their joint possession, so the court fee has to be paid.
No, not the court fee, value itself, because earlier suit, which is filed by the Irava, who is the sister of father of the plaintiff, that OS 149 was valued at 61,73,750 rupees. That will also.
That is in the year 2011.
Yes, ma'am. 2011.
Now, how much she valued now?
Now it is valued at 30.
34 lakhs.
34 lakhs 60,500.
No, there must be some other properties also at that point of time.
Same property,
Same property.
lots of
No, my lord, sir. That property on entire 1/4 share. Here I am claiming 1/4 of half share. In my father's share I am claiming 1/4 of half.
Yes.
So according to that I have
Claim
produced
may
a
continue.
sub-registered document.
Page 70 may continue.
Yes.
Present suit several properties.
Hmm. Yes. Market value 26 lakhs 35,000.
And you lots may kindly see page 59, where the earlier suit properties in the decree it is mentioned, page 59.
Hmm.
A schedule and B schedule. A schedule consists of 1 to 9 properties and B schedule 1 to 4 house properties.
Hmm.
And the very same properties have been incorporated in the subsequent suit also.
You are referring to some exhibit. Where is that? You are referring to some exhibit which is not considered.
The exhibit P 41 and 42, that is a decree, madam, which now page 59 is a decree.
Hmm.
The earlier suit was valued, madam, is 34 lakhs,
Hmm.
61 lakhs,
73,000.
73,750 rupees. Landed property is valued at 54 lakhs, 23,750, and 7 lakh 50,000 rupees is valued for the house properties, that is the rescheduled properties. And this is subsequent suit.
Please come to the order now.
Yes,
Come to reasons.
yes. Trial court has not at all considered exhibit P 41 and 42. May I read my page 13 starts. Plaintiff has filed the present suit for relief of partition separate position. It is a contention defendant that suit is undervalued. In order to prove this contention, defendant number 5, I am the defendant number 5 in the trial court. Defendant number 5 is examined as legal
You are reading where?
Page 13, no? That is input order.
Reasons, no.
The reason starts at page 12.
No, please 30.
Internal page 12.
Internal please
No,
5.
that is, I think, judgment model is earlier suit.
Oh, earlier suit.
Earlier suit. This is OS 23 of 2000.
Yes.
Page 13, no?
Yes.
Para 6 of the.
Hmm.
Plaintiff has filed the present suit for relief of partition separate possession. It is a contention with defendants that the suit is undervalued. In order to prove this contention, defendant number 5 is examined as DW1. But the defendant number 5 has not produced any document to show the suit property is undervalued. This is not correct. I produced exhibit P 41 and 42. On the other hand, the plaintiff is examined as DW1 and also one independent witness examined as PW2 and produced 2 documents, exhibit P1 and P2. Is the valuation given by the sub-registrar of Narbonne. As per exhibit P1, the value of the agricultural land per acre is 72,450 rupees in the year 2013-14. Plaintiff is claiming the share in the 9 landed properties totally measuring 21 acres, 17 guntas, and hence, as per exhibit P1, total value of the entire properties will come to 20 lakhs 87,345. Plaintiff has also claimed a share in the 4 house properties.
Instead of she has placed before the court the valuation by the sub-registrar. That's a relevant factor. Whether at that point of time, whether it is undervalued, overvalued, that's not. Now, if you say that that's not correct, proper, you should have brought your own. If you have any other document, you cannot rely on that. When like before in 2011, how it was. Ultimately, for the court to look at whether the value of the property, it is as per the sub-registrar's value, the market value. Just because somebody has valued it as something in the earlier suit, that cannot be a factor.
But the thing is, this not the trial court has considered only 2 documents, that is exhibit P1 and
No,
P2.
even for you also, that's what I'm saying. Now the court can only look at for any valuation of the suit property, we look at the sub-registrar's value. That's a market value. That's a book value which we look at.
Index value.
Yeah, then you have to. Then that is there before the court. If you deny or say that no, that's not the right document placed, you can only based on that.
But yes, produced only in respect of the landed properties. House properties, no document is produced.
In that case, you should have produced. That should be the document.
But I have produced the exhibit P1 and 41 and 42. Where
No, let's not go into that. What has been done in 2011? No, the suit is filed as on today. As on today, what is the market value as per the sub-registrar's office? That's only is a relevant factor. We can't compare it from how it was done earlier. whether it is done right, wrong, or whether it is questioned or not questioned.
And
Then what do you say about when you're seeking that, with regard to the house properties, where is the valuation?
My lords may kindly see, my lords.
Let's look at the document.
Issues has already framed. Issue number 1 to issue number 9. So, and he has taken a context and let the court may decide. So, I am claiming 1/4.
That is true. No, you filed the valuation slip.
Please.
According to him, like as far as the agriculture lands are concerned, you got it. Then there are about other residential the house or whatever it is, fee scheduled properties. For that also there should be a valuation. Where is it considered?
Let him raise that issue before the trial court. Now I have
Which
produced.
issue? What is the issue? Please come. Let me look at that issue.
yes,
Please.
case 13 only it is there.
Then what is the issue?
Case 13.
Whether defendant number 6 or prove that the suit is undervalued and this court does not have jurisdiction. Then, for deciding this issue, what are the documents that were looked into?
My lords,
No, please come to that sub-registrar's
Yes,
valuation.
page 97 and 98.
90?
Page 97 and 99. Two documents are produced and not.
97.
97 and
97 pertains to agriculture land.
agriculture land. Some of the agriculture land situated in different villages.
98, 99 is also
with
that.
regard to the residential premises.
No. Something you have shown that the valuation.
My lords, I have produced.
That is in the
these
decree mode I have
documents.
produced.
No,
Page
no.
number
Page number?
97 and 98. I have produced these documents. Exhibit P1 and P2, my lords. The finding of the trial court is that he has not
No.
produced any documents.
Only these are the properties? Only these 3 are the properties which you are claiming?
There are totally 9 properties.
Then where is the valuation for the
Kindly
9?
see, in first page there are 6 properties.
In first page.
97. Survey number 8/1, 8/2, 8/3, 56/2, 56/3, 51/6.
3 properties or
Next, my lords.
6.
Next. 214/5 B, 214/5C, 214/5.
Please come to the plate. Let's verify from that.
Please.
House property is not produced. Page 70. Plain copy.
8/1, 8/2, 8/3. Then 56.
I'm not denying that 1 to 9 of the scheduled properties they are produced.
Then B schedule.
These scheduled properties
That
not.
is also there.
It is not there.
No. They valued it 1 lakh, 150, 275, 3 lakhs.
Yes, this is valued, but they have not produced the subregister.
You are the one who is questioning that it is undervalued. You should have brought it before the court.
No, they have produced the conveniently not the landed properties. House property they have not produced. And trial court holds
For a moment,
it has
can you
got
see the
jurisdiction
reasons?
without considering that.
Para number 10. Page number 14.
Yes.
Para 10. The plaintiff is claiming share in 9 landed properties totally so and so, and hence as per exhibit P1 total value of the entire property will coming up to so and so. The plaintiff has also claimed share in all in 4 house properties. The defendant has not produced any document.
No, while you are valuing the properties, there need not be any basis. Randomly, whatever the plaintiff says, that would be the value while valuing the suit.
I have produced some register document.
Where is that?
Exhibit P1 and P2 is.
In respect of this B scheduled properties, you should produce.
Here,
No, we'll remand the matter, whatever both of you want to place.
for a
before the
moment,
court.
well, here, can you see? Further, the trial court has come to the conclusion in that page number 14.
Yes.
4 house properties. The defendant has not produced any document to show that the market value of the B scheduled property is higher than what I mentioned in the plaintiff. The plaintiff has valued B scheduled properties at rupees 8,25,000. Hence, the market value of total property is 20 lakhs so and so plus 825, it comes to 29,12,435. Whereas even he has not produced any documents.
You also not done. You should also, court should look at it. No, when you're saying that, just like that, whatever you say can't be the market value. For the landed property, when you have taken the sub-registrar's value, even for the urban property also, there is something.
And moreover, sir, already issues have been framed. And there are totally 8 issues have been framed.
Correct. But deciding this issue, Whether you have undervalued the suit, it should have been dealt with by the court properly.
I'll ascertain whether they have produced or not tomorrow.
Tomorrow.
Please.
At the request of non-counsel, the respondent pose this matter tomorrow as part of
Interim order may granted.
interim order earlier granted is extended.
Bill number 51, which is second law, another mistake, Mary.
Some petitioner melons.
Yes.
Only 1 week time.
Huh?
Only 1 week time.
Why?
Due to some inconvenience melons.
Inconvenience to
Inconvenience
you.
My senior. So. Can you
Interim
amend?
order is there.
No.
No interim order. List this matter when?
13 minutes.
Huh?
Next week 13.
Yes. List this matter on 13. At the request of non-counsel, the petitioner, no further adjournments.
Please speak low.
What's the best?
Yes. Next.
Bill number 50, Chetan Roy.
Therefore, petitioner, it is arising out of my inquiry under order 22 rule 5. Because I seek weeks accommodation, I need to secure instructions from the party. Weeks time, my lords. An LR application was filed. That is allowed. Challenging that present petition has been filed.
What instructions you want to get? List this matter on 14th. No further adjournments. At the request of non-counsel, the petitioner.
May I seek on 19th?
19th.
Please.
Yes.
Bill number 53, Sri Deshpande.
(490) of 2019 under section 127 of CRPC in the principal family court Belgaum. He is enhanced the maintenance allowances 3,000.
You are for the
I am for the petitioner.
husband,
Wife.
wife. What is the maintenance granted?
Interim 7,000.
7,000. What now you are seeking for enhancement?
Enhancement.
And what is the income of the husband?
He is a master.
Uh,
Now he is retired.
when he retired?
2021 madam.
Uh,
He got a agriculture land and 3 house property in Mediation.
divorce? When was the divorce?
Divorce was not filed. And he respondent got a contract with the second marriage.
He contracted second marriage. When?
Long back. Long
Mm.
He is agriculture land and handsome income. Salary.
What was placed on record to show his handsome income?
I am producing in lower court the payslip I have produced, and I have in lower court I have produced the RFR and BPC house property 223 and.
So from how long both of you are staying separately?
Since 1993, my lords.
1993,
my lords. In fact, my lords, I filed for divorce also, and that was rejected by the honorable trial court, and thereafter that was not challenged. Since 1996, my lords, I've been paying maintenance, and lately, my lords, I was retired, and in the year 2019, my lords, there were arrears, and the wife filed a writ petition for the recovery of arrears, my lords, due to which the Honorable High Court directed the Board of Education, my lords, to withhold 3 lakh rupees, my lords. And thereafter, my lords, the Board Education has withheld my pension, retirement funds, everything, my lords, due to which I am not able to pay maintenance, my lords.
Where is that writ petition?
My lords, I have filed
In the next matter.
pending for consideration. The matter has been stayed.
So now why don't you come up with a full and final settlement? So that we'll next is
Both are in the same.
it is also a RPFC, you are saying writ petition.
I'll give you the number.
And then we'll have along with that, come up with what is the final settlement so that we can close all these petitions and so that you will get your retirement benefits, huh?
Currently, I have no source of information.
That's what I'm saying, that once that intermodal that is vacated in the writ petition, basing on that some settlement can be arrived at, get instructions.
The purposely avoiding the maintenance.
What is the writ petition number? Give that number. List that matter along with this matter along with that, these two matters along with the writ petition on the day after tomorrow.
No.
Every accommodation may be granted.
Then we'll have it on 12th.
28.
Why you want any relief to your client on 20th?
Please.
Yes, next.
Okay. Number 54. Is Naled with it? Is Jayana?
Already, this matter is compromised. We communicate with the.
Passover?
54 Passover. Number 55. DMA. Madhekar. Sunil Desai.
No representation on behalf of both the parties. List this matter for dismissal tomorrow.
Number 57, 56. This is Somapur, this is Bhavatma.
Yes.
Wait, please, in this case, the respondent is the mother of the petitioner. The mother of the petitioner has tried a maintenance.
How much is granted?
In the 10,000 has been granted.
What is your income?
Agriculture, only agriculture. 4 acres land is there. Each petitioner is having 3 acres, 20 acres and 4 acres.
Counsel, the petitioner is present.
Already they have deposited 50,000 rupees.
Heard in part. No representation for the respondent. List this matter as part for tomorrow. Yes. Day after tomorrow. Huh? Intermodal granted earlier is extended to the next week again.
Number 57. You will compromise. We are not done.
On behalf of respondent for 2 minutes.
Use the file.
Kindly next week,
Huh?
kindly next week must seek some instructions.
What instructions you want to see? Use the file. Or representation. This is for dismissal on 13th of November.
Please.
Counsel for the
My lord, in 57, I represent respondent number 1 in this matter, my lord. 57, my lord.
Yes.
I represent respondent number 1 in the matter, my lord. I think the other side has, respondent number 2 has taken time. May I request your lordship to note my presence in the order sheet, my lord?
Counsel for the respondent number
1, my lord.
1 is present. Yes.
Please, my lord, please.
Yes, next.
Petitioner Naled. Oversight file is misleading. Student accommodation.
At the request of the counsel petitioner, list this matter day after tomorrow. No further adjournment. Yes.
Number 59. All the property. Top people.
Yes.
Husband's dividend.
You are asking for time. No amount is paid till now.
Only 40,000 is paid and announced.
How much should be paid? It should have been paid.
It should, the arrears is more than around 80,000 to 1 lakh, the amount is signed.
When are you going to pay?
In the meanwhile, he says he is paid now. No, he is not paid.
We'll list this matter on 13th. By the time we get instructions, If the amount is not paid by then, you can vacate the interim order. As for the order, when counsel respondent submits that, as for the order passed by this court, the entire amount is not paid and there's still arrears, then counsel the petitioner seeks time, place this matter on 13th of November. By the time if the amount is not paid, the interim order granted by this court stands vacated.
Okay.
Yes.
Bill number 60. Law.
Matter is likely to be compromised. Mediation is first.
You want to go for the mediation?
Yeah.
It is submitted, both the counsel submit that there is a likelihood of settlement. The party shall appear before the mediation center on 19th November. Yes.
Interim order.
Interim order granted is extended to the next date of hearing. Yes, next.
Bill number 61. Shall very good.
60?
61.
Yes.
Transfer from the ability to Belgaum, carried by the respondent area for education on the
Seeking transfer from
ability to Belgaum.
Hubli to Belgaum.
Last occasion.
How much is the distance? 40 kilometers.
95.
Huh?
95.
Hubli to Belgaum.
Recently, the petitioner has been working with Bangalore.
Working in?
Bangalore. In that affidavit, she has filed, she has stated that she is working in Bangalore. And she have produced, filed another CP also, seeking transfer from the Hubli to Bangalore.
Where is that seat?
Has been connected also because of.
It's not there in the list.
2024. 2024. It has been.
You gave a wrong number. Give the correct number.
2024 is we are 2023 has been.
Oh, written. Post along with CP 100235 of 2024.
It's a FR number.
FR number. FR number 100235 of 2024. Yes, next. This tomorrow. Next tomorrow, already granted is extended to the next date of hearing. Yes.
Number 62. Number 63. Number part.
Husband's petition.
There is a counsel with respondent. Counsel with the petition is present, heard in part. Yes.
So I'm representing respondent, my lord.
Yes.
Yes. The Amicus order 11,000.
11,000.
Yes.
8,000
to the wife and 3,000 to the son.
You're for the husband.
Yes.
What's your salary?
As per the petitioner, 25,000 is salary. And he's doing a guest lecturer level. And the wife, without any reasons, left the company of the husband level. And she's a graduate of BA, B.Ed level. And having a distinction in the degree level. In spite of that, she's staying with her parents.
From how long you people are separated?
From 2000, from more than 4 years now.
Any MC is pending?
No, madam.
Both of you not filed any case?
Well, earlier to this, my lord, there was a 498 case, my lord.
No, MC is not filed by any of you.
Not filed. And even the last occasion it was referred to mediation, my lord. And the petitioner requested to give him permanent alimony to the extent of 4 gunta land, my lord. He's having given total 8 guntas of land, my lord. In spite
any
of
children out of the
only one child.
You refuse for that?
My lord.
You refuse for that?
The wife was refused, my lord.
You are ready for 4 guntas of land?
Yes, my lord, I am ready, my lord.
She wants 8 guntas of land?
My lord.
She wants 8 guntas of land?
No, my lord, she is claiming money, my lord, not a land, my lord.
That 8 guntas of land is from village, my lord, and it's a joint family property.
No, For giving money, he should also have money, isn't it? According to you, he is having money.
He is having money. He is getting a salary. He is working. And
No, but the salary cannot be given as a lump sum amount.
a lump sum. We don't want lump sum. We want.
Forever you want maintenance. And why is your client not working?
She is just completed graduation. Madam.
No, she's a BCom,
BA.
No,
It's totally false. Because externally she has completed a degree course.
You deny that like she didn't do BA.
No. Yes.
You have the documents?
I will secure the petitioner before the Supreme Court. Secure the petitioner along with the documents.
Now what is that she is expecting? One lump sum amount? Not to, why unnecessarily, why in this litigation, why do they want to spoil and waste the time of their life, precious time? If you're not interested to join the husband, happily stay apart, take whatever you want. How will this go on forever? Ask them to come to the court on 27th of November. Yeah, both the parties shall appear before the court in chambers at 2 o'clock. 27th is there. Look at it. 26, 28. 28 at 2 o'clock. Yes.
Submission is 57. The matter was called as an X on court of court.
What happened to that?
It is kept for dismissal. I am ready with the matter.
Take 57. What about respondent? Inform him. We will pass over the matter.
Please.
57 pass over.
Please.
Yes, next.
Number 64.
Yes.
Again, we have instructed, but still we are not. I have instructed the client, but still we are not given any document.
But that's what I remember this. We will dismiss it.
Please.
Lord, I'm representing respondent, my lord. I'm representing respondent, my lord, and he has paid only 9,000, my lord, since from the order. There is a balance of 2,99,000, my lord.
Had passed an interim order. Not 12.9, just
There is no interim order, my lord.
There is an interim order.
No, my lord, on the payment of 75,000 rupees.
There is an interim order on 27/9/2024. How can you not notice that?
My lord, yes, my lord, but 8,000 has been reduced to the 5,000, my lord.
2024, the stay was granted by this court, subject to the petitioner paying a sum of rupees 75,000 within 1 week, and another sum of rupees 50,000 within 2 weeks, and file an affidavit of assessor liabilities, specifically stating whether the petition is paying GST registered under Goods and Services Tax Act, and whether petition is an income tax assessee, and continue to pay maintenance at rupees 5,000 to respondent number 1 and rupees 2,000 each to the other respondent on or before 10th of every month. And the court had directed that the affidavit shall be filed before 16/10/2024. Learned counsel appearing for the respondent submits that the interim order passed with this court is not complied with. When this matter came up on 21/10/2024, learned counsel for the petitioner submits that he has informed the same to the petitioner and there are no instructions from him. Then on 21/10/2024, this court had passed an order directing the matter to be listed on 28/10/2024, and it's also made clear that no further adjournments will be granted on the next date of hearing. on 28/10/2024. Again, the matter was directed to be relisted on 4/11/2024. And on 4/11/2024 also, the same submission is made before the court. And this court has observed that if the petitioner has not filed the statement of assets and liabilities by 6/11/2024, the petition shall be dismissed on that ground alone. Today, when the matter come up before the court, when counsel submits that, in spite of his best efforts, he could not secure any instructions from the client. Considering all this, it appears that the petition is not interested to pursue the matter. Accordingly, this petition is dismissed for non-prosecution. Next.
Syllabus 65. Even board of take upon.
Yes.
There was a clear order of stay, my lord, and with the direction to submit furnishing the copy of the payment of. So, law documentation is given. I submit the documents. They have paid any amount before the trial court, and it was a subjective conditional order and verified it.
At the request of your counsel, the petitioner lists this matter on 14. By the time if the interim order is not complied with, the petition will stand dismissed on that ground.
I'm ready to go with the merits.
No, I said you have to pay the amount first. You have to comply with the interim order. On that day, if you don't, we'll dismiss it. We'll not even consider on the merits of it.
Okay.
Interim order has to be complied.
Please.
Yes.
Syllabus 66. Will start on this agreement.
It was referred for mediation.
It failed.
Now,
Where is the counsel for the
I am told,
respondent?
my lord, the wife has filed one more petition for seeking enhancement of the maintenance package.
What is the number? You have the number?
Number, my lord, notice is not at order. They are informing me in the morning.
We'll pass over so that once we get the number, both we can club and post.
Like,
Pass over.
66 password. Syllabus 67. Syllabus 68. 8 party.
Almost case has been allowed. We are challenging that the sole ground on which the trial court proceeds to allow the 7-11 application is that the property falls short of 14 square meters. It is a commercial property. Whereas the pleading consistently says that it is beyond 14 square meters. Even the documents which are placed on record shows that it is.
Wrongly find chamber possible.
Wrong file. In their place tomorrow. Tomorrow, the registration place the correct file. Yes.
Syllabus 69. Section 31.
White petition, seeking transfer Belgaum to Bagalkot.
Belgaum to Bagalkot. What's the distance?
It's a 142.
Any case pending at Bagalkot?
128%.
128. The present petition is filed seeking transfer of MC number 330 of 2017, pending on the file of the Family Court Belgavi to the Family Court Bagalkot. The facts of the case are that the marriage has taken place on 16/6/2014 and in view of the differences between the parties. MC is of which year?
2017.
And then how it can be transferred now?
My 2013 the respondent ex party
You filed
subsequently filed miscellaneous. That is the ex party is set aside and
you file the case sheet, the order sheet of the trial court. The petition is directed to place before this court. The trial sheet on the order sheet on the docket order of the in the MC. Interim order granted is extended. List this matter on 19th. By the time you should file. Yes.
Syllabus 70. Party.
I tried to transfer the matrimonial case bearing MC number 74 of 2024 from the Honorable First Additional Family Court Gadag to Honorable Family Court Dharwad.
How much is the distance?
It is 80 kilometers.
The present petition is filed. What about the notice is served? The present petition is filed seeking transfer of MC number 74 of 2024, pending on the file of the first additional principal judge family court Gadag to the family court at Dharwad. The facts of the case are that the marriage was solemnized at Gadag on 27/3/2023. In view of the differences between the parties, the respondent husband had filed MC number 74 of 2024 on 2/5/2024. Thereafter, the petitioner herein had filed criminal miscellaneous number 165 of 2024 under section 125 CRPC, seeking maintenance on 13/6/2024. It is submitted by the learned counsel for the petitioner. Next para. It is submitted by the learned counsel for the petitioner that the parents of the petitioner passed away, and the petitioner is having a brother who is staying at his working place at Bangalore. As such, he is staying at her uncle's place at Dharwad. Her uncle is an old-aged person living on the pension, and due to old age ailments, he cannot accompany the petitioner to attend the family court at Gadag. It is submitted that the distance between both the places is 80 kilometers. It would be very difficult for the wife to travel all the way from Davangere to Gadag. Hence, the matter may be transferred. Though notice is served on the respondent, no wakalat is filed on his behalf. Next, having heard the learned counsel for the petitioner peruse entire material on record, considering the fact that the wife is residing at Davangere and the distance between both the places is 80 kilometers, and considering the inconvenience caused to the wife, the court deems it appropriate to pass the following order. It's Dharwad. Considering the same, this court is passing the following order. The so-and-so pending on so-and-so is withdrawn and transferred to so-and-so accordingly alignment. Next.
So number 71. Why petition for seeking transfer? MC 59.
Which year is FC?
But the husband has filed in the Gokak
Which year?
24.
24. Any cases pending at the place which you are seeking?
124 is pending to Hubli. But from Gokak to Hubli, not more than 150 kilometers.
150 kilometers. Yes. The present petition is filed seeking transfer of MC number 59 of 2024, pending on the file of the first edition, senior Judge Gokak to Principal Family Court, from Principal Judge Family Court Hubli. The facts of the case are the marriage was solemnized on 22/7/2017. In view of the differences between the parties, the wife had left the matrimonial home, and on 5/1/2024 she had filed criminal miscellaneous number 4 of 2024 seeking maintenance before the Principal Judge Family Court Hubli under section 125 CRPC. After receiving the notices in the said petition, husband had filed MC number 59 of 2024 under section 9 of the Hindu Marriage Act seeking restitution of conjugal rights. Next paragraph, counsel appearing for the petitioner submits that the distance between both the places is about 80 kilometers, 150 kilometers. And it would be inconvenient for her to travel all the way for 50 kilometers to attend the court on each date of hearing. Concerning the next part, though notice is served on the respondent, no wakalat is filed on his behalf, considering the reason, considering the inconvenience that is caused to the wife, that is being caused to the wife, and that the distance between both the courts is 100 and the distance between the place where the wife is residing and the court is 150 kilometers. This court deems it appropriate to pass the following order. The so and so is withdrawn and transferred to so and so. Accordingly allowed. Next part.
Number 17. Follow order part. One student.
Yes.
Wife petition is 1 minute.
From where to where?
Hubballi to Bukkeri.
Distance?
150 kilometers.
And which year is the MC?
24 minutes.
Very.
Belgaum is the bit convenient because their wife fled to the husband in the Bukkeri and Belgaum.
You file your objections?
I will file it.
For like counsel respondents each time for filing objections. This is matter on 19th of on 20th of November. Interim order earlier granted is extended till then. Yes.
Number 73 answer. Number 74. Number Ajay respondent.
Yes.
On behalf of Ganpati Bal, seeking transfer from Karnataka to Shimoga, it is 130 kilometers. And for the wife,
Which year?
24 days.
The present petition is filed seeking transfer of MC number 34 of 2024 pending on the file of the Senior Civil Judge JMFC. What is that? How do you spell it?
Please, 1 hour.
Hanawal to the Senior Civil Judge and JMFC Court. Enter Tirthahalli. The facts of the case are the marriage was solemnized between the parties on 19/11/2020. And in view of the differences, the parties living separately. And on 29/7/2024, according to the wife, the husband approached the Court of Senior Civil Judge and JMFC for restitution of conjugal rights and filed MC number 34 of 2024. It is the case of the wife that the distance between both the places is 130 kilometers, and there is no regular public transport from the place where she is residing to the court, and it would cause a lot of inconvenience and hardship to the petitioner to travel on the every day of hearing. Next para. Learned counsel appearing for the, though notice is served on the respondent, there is no wakalat is filed on his behalf. Next, having heard the counsel for the petitioner, there is a material on record. Considering the fact that there is the distance between the place where petitioner is residing and the court, it is 130 kilometers, and also proper public transportation facility is not available. And further considering the inconvenience being caused to the wife, this court deems it appropriate. This court has allowed, this court is passing the following order. So and so, allowed.
Number 71. Respondent.
No representation for the petitioner. Oh, same one. From where to where?
From Kungol to Hamiri.
Distance?
80 kilometers.
Which year is the MC?
24.
The present petition is filed seeking transfer of MC number 47 of 2024, pending on the file of the Senior Civil Judge JMFC, Kungol, Dharwad, to the Court of Principal Judge Family Court, Haveri, where criminal miscellaneous number 125 of 2024 is pending. Facts of the case are the parties were married on 25/4/2021 at Hosali village, Punggol. In view of the differences between the parties were residing separately. And on 31/7/2024, the husband has filed a petition for restitution of conjugal rights. That is MC number 47 of 2024. On 21/8/2024, the wife had filed criminal miscellaneous number 125 of 2024, seeking maintenance of an amount of rupees 25,000 to herself and rupees 10,000 for her, each to her minor children. Land counsel appearing for the petitioner submits that as a criminal miscellaneous is pending on the file of the family court Haveri, and as the distance between both the places is
80 kilometers.
80 kilometers, and she has to take care of the children, and it's difficult for her to travel. The petition may be, the MC may be transferred. Expira. The notice is the same. Having got the counsel for petitioner, there is a material on record concerning the fact that already criminal miscellaneous number 125 of 2024 is pending on the file of the family judge Haveri, and the fact that the petitioner has to take care of 2 children and the distance is 80 kilometers, considering the inconvenience to be caused to the wife. Same.
Please.
Next.
Number 76.
Yes.
Vice petition, my lords, seeking transfer from Upani to Dharwad. Distance is 252 kilometers.
How much?
232 kilometers, my lords.
Which year is the MC?
2024, my lords.
Let also the petitioner submits that husband has filed MC number 556 of 2024 on the file of the senior civil judge and JMFC at Nipani, and the petitioner is a resident of Gadak. The distance between both the places is 232 kilometers. Considering the reason stated, they shall stay for further proceedings in so-and-so till the next date of hearing. The petition is permitted to take put hand summons on the counsel appearing to the respondent before the trial court, and shall file a memo to that effect by 21st of November. 20. Yes, next.
Number 77.
He's seeking some time to produce the record. 77 and 77 and 83 at the request of the government leader. List this matter when? On 21st.
Both the matters will be written in order.
Interim order, just look at it. If the interim order is there, extend it till the next date of hearing. Yes.
Number 78, number 79. Article 4.
No representation for the petitioner. Passover? Yes. Inform it. Yes, Passover.
Number 81. 81.
Respondent on wife had filed a petition and awarded by CRPC. With a trial court awarded date on interim maintenance.
And what is the income of the husband?
He is owning a small extent of land in his name. What documents he has produced, those properties are as his property standing in the name of mother.
Now, what do you do? What is the occupation?
He is agriculture. Agriculture is totally owning about 2 acres, 2.5 acres land in his name, and he has to maintain his old age mother, suffering from diabetes and all.
And so, then what is happening to your mother's property? You are the only one. And
No,
you are
there are
taking care of her.
sisters in Dhara. There are sisters. Son is only one son. He is maintaining his mother.
Except the agricultural lands, no other income?
He is 12,000 rupees pension to his mother madam. Because of the project petition, father was in police department. He died after his death, pension is coming to his mother madam. And 7 acres, 12 guntas land is in the name of the mother of the petitioner, and 2 acres, 3 guntas in the name of project petitioner. And also he had 3 housemates.
That's also there on the.
Okay, 2 houses in the name of mother, 1 house is in the name of project petitioner. So he has sufficient income to pay them. In the year 2022, the order is passed by the trial court. Till today, they are not paid. They have paid only 5,000 rupees before the
Stay is there.
No, madam.
Then why you are not filed EP?
They have filed, madam, but they are submitting that the writ petition is pending before the High Court. That on that ground, they have not issued any warrant. Trial court.
Yes,
So,
will
8,000 can lead to the registration. Moreover, my lord, you see who has left the company of the petitioner.
All that has to be decided. Any matrimonial cases are pending between the parties.
MC petition is filed by the husband.
What is, on what ground?
On ground of cruelty.
No, it's not your case that it is desertion.
Cruelty and desertion.
Then the court will decide.
But my lord, earlier, he has to maintain his old age.
Why should you maintain when she is getting 12,000 income?
Pension.
Pension.
Pension, but he has to look after her. And,
for looking after her, you require some physically, you have to do it. Monetarily, you don't have to do when she herself is self-sufficient with 12,000 rupees. And with all that income, and when you say that you have to take care of the mother, all her mother's property and all, everything is managed by you.
Taking care of mother's property, he is unable to get income because he is agriculturist.
What is the wife? What is her qualification?
Graduate. They are taking some coaching in the Dharwad. Huh? She is graduate, become BA graduate, but she is not doing any work.
Why?
Because of the BA graduate degree, she is trying to get a job, my lord, but not get till today. She has not get any.
From how long she is idle without work?
Sorry?
From how long she is not working?
No.
When, from how long they are separated?
See, because of his harassment, she is residing in parents' house.
From when?
2022, madam. From 2022.
Then from 2 years you are not getting any job.
No, madam. There is no confirm by the government also.
He is an agriculturist.
Yes, he is 9 acres, 15 guntas land, madam.
That's what. He is an agriculturist. He has to work, and you are an educated person. You don't do anything, and you always want husband to support you. Why?
Because she has not any source of income, my lord, and she is.
You should do it. Not that.
But there is no any opportunity to get a BA graduates in the Karnataka, my lord. Even BA graduates can't get any job in the Karnataka government, my lord.
Why you?
And also in private source, private education institution as private institutions.
It's not necessary that it should be a private educational institution or a government. One has to eke out their livelihood. They can do a private. You will get any other job to do.
There is no opportunities to the PhD holders and the BA graduates in the position. And also the trial.
We will reduce it to 6,000.
In the trial court also said they are trying to compromise, but he has not agreed to compromise.
Yes.
He is ready to take the step.
She doesn't want to come back. Compromise means she wants money. What is that your client is ready to give?
After filing this 25 CR,
why don't you,
he filed
no. Why don't you come out with what is that you want?
Because of his cruelty, my lord. She is residing.
No, what I am saying you're not understanding. I am saying, if you want to compromise, what are the terms of the compromise? Why don't you share with him?
Yes, already said by the trial court, he is not ready to pay any maintenance or permanent alimony. I'll get instruction. He may be referred to mediation.
Can it be referred?
Maybe, because in the trial court it was failed.
It failed. Then you get instructions. Learned counsel for the petition shall get instructions, like what are the terms of the compromise from the side of the husband. This is matter on 19.
Please.
Number 18. 8.1. 8
Proceedings under section 125, Lords. Wife files an application under section 91 of CRPC seeking to summon the account details of the in-laws who are not even parties to the proceedings. That application is allowed. Even these petitioners who are in-laws, they are not even being heard on that application.
In which proceedings?
125 CRPC proceedings.
How are the in-laws concerned with this 125 proceedings?
Yes, Lords, that is what. We are the in-laws who are petitioners.
And you are not a party to this.
We are not a party.
Let's see the imperial order.
Yes,
My lord, on submission. Husband of the petitioner, after the marriage, left her in-laws' home and went to abroad, that is Qatar. What all he earned there, that amount has been transferred to the accounts of the petitioners, their petitioners. He himself has admitted in his past examination.
For that it is, no, the order is passed.
No, not like that. He is having sufficient source of income to pay the maintenance of the wife. Even to establish that also.
Let us see the order.
Please, my lord. Lord, you should get it at page 33.
30?
Page 33. Even I have filed that past examination extract also, my lord.
33.
Yes, Lord.
Let's see that.
Unreasoned order. 19/8/23, your lordship will get at 3 p.m. objections to be filed. Call on 22/8. 22/8.
I don't find that order at all.
Page 33.
Page?
33.
Where is that? What is that?
Yes, nothing is there, my lord. 22/3. Objection to I under section 91.
What is this order? How can the court pass that kind of an order? There should be some reasons.
Yes, my lord.
Where is your IA? Where is this IA filed under 191?
Please,
I
can hear, my lord.
Page number 25. Sorry. Page number 32.
Please come. Approved by the order dated 22/8/2023, passed by the so and so. Passed in I number. What is the number? Passed in IA filed under 91. Filed under section 91 of the CRPC. The husband is before this court.
In-laws.
The in-laws are before this court. Let counsel appearing for the
Respondent.
The counsel appearing for the petitioner submits that the court, the counsel of the petitioner has drawn the attention of the court to the docket proceedings dated 22/8/2023, where it is simply stated that the IA is allowed. The counsel submits that the order is bereft of reasons, and the same is liable to be set aside. In a petition filed under 125 CRPC, the wife, the in-laws have nothing to do, and there have been an order is passed against them, and the same is not a recent order. Land counsel apparently on and submits that the husband left the wife at the in-laws place, and whatever he is earning working in Qatar, he is continuously transferring the same to the wife, and for that reason they want the bank statements of the in-laws. The court had rightly passed the order. Next para. Having heard the land counsel of the petitioner, there is a material non-report. An IA is filed under section 91 CRPC by the petitioner, by the wife. When an application is filed and the husband had filed his objections, the court, while passing an order, should pass a reasoned order containing on what basis the court is allowing such application. Unfortunately, the order that is impugned is without any reasons and such an order cannot be sustained. In that view of the matter, the order dated 22/8/2023 is set aside and the trial court shall consider the application that's filed by the wife by looking into the objections that are raised by the husband and shall pass a reasoned order.
One submission, may I may permit it. The husband's objection is taken as not filed on 22/8, on 19/8/2023.
Let counsel for the husband submits that he has already filed the objections.
And it is taken as not
But
filed.
it is taken as
Husband did not file objection, therefore it is taken as not filed before the trial court.
the husband shall be given, husband is permitted to file his objections and the court shall consider the same and pass appropriate orders within a period of 2 weeks from the date of receipt of the copy of the order. And within 2 days from the date of receipt of the copy of the order, the husband shall file his objections. Yes.
Next one is related to the same.
What is that? What is next?
Connected matter, I am appearing for the husband. The way I am challenging the order of maintenance, the entry maintenance, 10,000 rupees is ordered.
Give 82.1. Now this order is in 82. The order that is passed is in serial number 82. Now this is 82.1. No. By setting aside the order and the matter is remanded back to the court. Yes.
The marriage is not solemnized on 16/12/2013. She has not even stayed for long days. She left the matrimonial home and started filing complaint. 490 is also filed, and also proceedings, restitution, and also the divorce. Now, the maintenance petition is filed seeking interim maintenance of rupees 10,000 rupees. Is ordered by the trial court. She is able to earn itself. She is educated and MA B.Ed is her qualification. And whereas because of the torture of the respondent wife, he has forced to resign his job and now he is totally not unable to maintain himself because old age parents are there and he has to spend medical expenses for their parents also. That has not been considered by the trial court and
as litigation expenses till the disposal of the petition. When it is when the operative when the discussion of the order shows that the 5,000 is towards maintenance. No, it is for maintenance and for litigation expenses.
And for litigation expenses.
Both.
The operative portion may not.
And it comes only as litigation expenses. And then 5,000 how he can't pay? What she will do if you don't pay?
Making 2 minutes in education qualification. And the background that minutes he was working as a teacher. And because of these litigations minutes, she left the job.
Let's see that. Let's see the order. With the Basaveswara International Public School showing that the husband-wife worked as teacher, respondent wife worked as teacher from 25/2022 to 11/11/2022 and was drawing net salary of rupees 12,000 per month. Then you are capable of earning, and he is earning 10,000. You are earning 12,000.
As far as that aspect is concerned, my submission is my proceedings for maintenance is also pending. There till today maintenance has not been
No, this is for maintenance and litigation. No separate petition is there. If you look at, no, please look at para number 8.
Yes,
it is for both. That's why court has ordered both.
My submission is not till maintenance is granted by the competent court.
Which court?
I have filed it before the Mudhol court. That is not before this court. JNFC court Mudhol, where I am residing.
You filed criminal miscellaneous in that.
Yes. 125 proceedings are initiated.
How many times you will have the maintenance?
Till maintenance is granted, there will not make this order.
How can it be? How can now MC is there before the court? I can understand this is a domestic violence case and other. When MC is before the court, you filed an application for maintenance. Why will you get maintenance under 125? It can't be. You cannot have both. Please come.
My only submission is not both are independent rights. My submission may kindly be taken.
You can't have so many. Will dismiss this petition. Will allow this petition.
One request is on the capability of earning, let there must be any finding. That is the request.
No, that's the only reason on that the court can allow this petition.
That will have direct impact on my proceedings in criminal miscellaneous. I think
you are exactly doing what is contrary to what is stated in Rajneesh versus Neha.
Overlapping jurisdictions, I understand.
No, I can understand 125 CRPC is exclusively where the divorce is granted or the otherwise, then in that case or no other proceedings are pending, then you will go under 125. How can you ask for MC under 24 and again under 125?
My request is, my lord, since this happens to be an overlapping claim for maintenance, on that sole ground it may kindly be set aside and it may be kept open for me to be urged in the criminal miscellaneous.
Why you get a better judge there in 125?
I may not be in a position to concede on record, so this is the most
agreed with the orders passed in MC number 128 of 20, in I number 4, in MC number 128 of 2022. The husband is before this court. The wife had sought for maintenance and litigation expenses of an amount of 25,000 per month. It is the case of the husband that the wife is earning. Both of them are working as teachers and earning, and she is not entitled for any maintenance. The court has observed that the wife is that the husband is earning, the wife is not employed as of now, and granted an amount of rupees 5,000 per month towards litigation and maintenance. Next paragraph. Learned counsel appearing for the petitioner submits that when the husband is earning 10,000 and the wife is also having the capacity to earn, and also there is material to show that she is earning, granting of an amount of rupees 5,000 as maintenance is on the higher side. He further submits that wife had already filed a petition under 125 CRPC, and the same is pending consultation before the
Additional Civil Judge and JMFC Mudhol.
Additional Civil Judge and JMFC Mudhol. But unfortunately, you court cannot pass such an order saying that because at 125 is pending, I will dismiss this. It has to be independently dismissed, or you can, or on your concession saying that let there not be any order in the let this be allowed, and I pursue my remedies in 125 CRPC. Then only I can do. Because basing on 125 pending, then it amounts to a wrong precedent.
I may not be in a position to concede on, because that is my discussion.
Then tell the client that it's going to be dismissed on merits, because we can't.
Day after tomorrow.
Day after tomorrow, the request of then comes for the respondent. Yes.
So number 18, 8 part.
Number 4.
Huh?
Asked for respondent number 4 number. I filed statement of objections to this petition.
Yes.
The
What is this order?
Mandamus is sought to consider the representation.
What is the representation?
The respondent hearing will contesting respondent holds a bar license, was operating in my property, which was on lease for a period of 11 months. The lease has also
That
expired.
11 months from when to when?
It commences from 1/4/2023 to 28/2/2024.
20?
2024. After expiring
When is his application?
for
Renewal?
renewal application that has been recently renewed is what he has filed in his statement of objection.
It's already renewed.
It is already renewed.
till 2025 it is new number.
It is?
Till 2025, it has been renewed now.
Then without there being a premises, how can it be renewed till 2025 when your rental agreement itself lapses by 28/2024? You don't consider all that. Take that. Huh? No. When you have renewed the license.
In the month of May 2024, they have made a representation number.
No. When your license lapsed, or when is the date for renewal? From when to when it is renewal?
2024 renewal of.
When?
21/6/2024.
21/6/2024, when you are renewing the license, that is on 28/2024 is the lease. How this judgment will apply? No, it is not the question of, please understand, I look at it. Let's start, understand the facts first. What your submission is, during the pendency or while the license is in vogue or after renewal, if he changes his mind, then No. When you are renewing it, what are the documents you require?
No, that may not be. Rule 4 of the excise rules. Rule 4 of the excise rules.
Let's see what he wants to say. Yes, page number, which para?
It may be afforded that the license has to be granted with the same authority on the basis of fulfilling the requirements of the Act and the rules made there. Though the requirement of any consent of the landlord is not specifically there, but for administrative convenience has been obtained as in the present case. Once the consent is obtained for the specific period, it is not necessary.
No, please understand, it is not about consent. It is about there should be a lease. There is no lease. Lease is expiring in the month of August.
Lord.
And you are giving 1 year license for him. You are renewing it for 1 year. Then how will he do it? How can you give a license? Because this rental agreement itself is going to be last for 28.
Lord, one submission. In June 2024, they have collected rent from me, my lord. I have produced the statement of bank statement.
Please look at that excise rules. It can't be. How can it be?
Excise rule.
Or which rule?
Karnataka Excise Sale of Indian and Foreign Liquor Rules 1968.
Uh.
Rule 4. Rule 3 and Rule 4, my lords. In Rule 4, sub-rule 2, it shall have its own land and building or shall have obtained on lease for a term of 11 years or more.
No. You are reading rule number?
Rule 3 license, Rule 3 licenses.
Yes.
Rule 3 clause 2 retail offshore licenses for vendor of Indian liquor or foreign or both, not to be drunk on the premises. Then next, license to the clubs. 3, 4, after that, 4 clause 2, if your lordships could kindly see, it shall have its own land and building or shall have obtained it on lease for a term of 11 years or more. 4 clause 2.
What is this is running? It's a
CL2 license club, CL2 license liquor shop.
Since 1989, I am running a shop in
So-
permission, my lord.
So you should have lease there.
My lord, February 2024, the lease agreement is completed, my lord. Till June 24, they have collected rent per month, my lord. It means that the rent is,
for example,
lease agreement is
please
continued, my
understand,
lord.
you are having lease, now they have renewed your lease till 2025. And your lease agreement with them expires by August 2024. What will you do? Where will you run? And because you are having license, they are compelled to renew the license, renew the lease.
Well, also while granting the license, my lord, the government, the deputy commissioner has followed all the due process while granting license, my lord. May I read my statement of objection, para number 5?
What I'm saying is, let's not look at any of the legal provisions. Just a simple logic. You want to start your business in that premises. For that, it is not your own premises. You are taken it on lease. So, first condition is you should have a lease. A lease which is expiring in 2 months, can you have a renewal for 1 year?
But they have collected rent.
Not collecting the rent. What you require is a lease deed. Isn't it? The rules itself say either it should be your own land or you should have a lease. Where is the lease?
Though my lord, lease is expired, but they have collected, my lord.
That is not the consideration. They should look at it and let his representation be looked into. If there is no lease, then they have to cancel your license. Consider. Yes, consider.
Lord, my family is depending on
Please
the
don't,
shop business, my lord.
but that is, the court cannot consider all that. It has to be by something which is known to law. Please come. The present petition is filed.
Lordships can move to the next court.
The present petition is filed, seeking a mandamus to respondent number 1 to 3 to consider the representation dated 28/5/2024. It's a case of the petitioner that is the owner of the commercial premises, that is shop premises bearing old door number 408/1 and new door number 446 situated at 10th ward opposite to town municipality, Harpanahalli. He has rented out the said premises to one Devdas on 24/3/2023 on monthly basis to run the wine shop for a period of 11 months from 1/4/2023 to 28/2/2024. It is stated that the shop premises is a very old structure and it is in a dilapidated condition and there is a life threat to the inmates of the said shop. As such, he requested the tenant to vacate the premises for the purpose of effecting necessary repairs and the petition is intended to continue the rent the said premises. As such, he made a representation on 28/5/2024 to respondent number 1 and 3 and requested them not to renew the license of the liquor shop. It is the land council appearing for the petitioner submits that under Rule 4 of the rules, the applicant has to specify the location of the premises where he has to conduct the business, and his right to carry on the business is restricted to the place mentioned therein. And under Rule 5, the Deputy Commissioner has to make inquiry, and if he is satisfied, then only the license can be granted. It is stated that no objection was taken by the respondents from the petitioner, and after the lease has come to an end by reflex of time, the license cannot be renewed. That the consent of the landlord is a condition precedent. When the respondents have failed to consider his representation, he is made to come to this court, having no other alternative remedy. Next part. Land counsel appearing for the land government pleader appearing for respondent 1 to 3 had relied on a judgment of this court in case of B.C. Narasimhamurthy versus the Commissioner of Excise, reported in ILR 1988, Karnataka 2596. Basing on this judgment, he submits that once a consent is obtained for the subsequent period, it is not necessary that such consent has to be obtained for renewal of license every year. Grant of license cannot be regulated by the whims and fancies of the owner of the premises. Basing on this, the council submits that no permission, no NOC, no permission, no objection is not required from the owner of the premises as stated by the petitioner. Next part. Land council appearing for the for the unofficial respondent, that is respondent number 4 of the licensing, submits that already the license is renewed on
21/6/2024, my lord.
21/6/2024.
And it is valid till
and it's valid
2025, my lord. 2025, my lord.
It is valid for a period of 1 year.
1 year.
1 year. He submits that though they have come up before the court that there is no valid lease, but they've been collecting the rent from the
till 2024, my lord. Till they have collected rent, my lord. Till June 2024, my
till
lord.
2024. He submits that when they are collecting the rent, they cannot come up before this court with such a plea. It is also submitted that the entire family is depending upon the income derived from the said shop, and if at this point of time any action from the respondents would cause a lot of hardship to the respondent. Next part.
And one submission. I have filed second objection by producing the annexure R1, my lord, building fitness certificate.
He submits that the case of the petitioner is that the building is in a dilapidated condition. Along with the objections, he has filed a fitness certificate issued by the municipality.
Private civil engineer, my lord.
By a private civil engineer, stating that the building is in a fit condition. He also relied on the very same judgment relied on by the learned government pleader, and submits that basing on the whims and fancies of the owner of the premises, the license cannot be rejected, and the respondents have rightly granted renewed the license. Next paragraph. Having heard the land counsel for the petitioner, land counsel on either side, register material on record. The first and foremost, the judgment that is relied on by the land counsel for the respondents do not apply to the facts and circumstances of the case. Whenever the license is granted, as per the rules, the person who is seeking the license Either he should have his own premises or there should be a lease to premises. To show that there is a lease in his favor, we have to submit the lease document, the lease deed. Admittedly, in this case, by February 2024, the lease deed, the lease, that is the agreement of lease between the petitioner and the fourth respondent has expired. Then on what basis the respondents have renewed the license of the fourth respondent is not known. Under these circumstances, this court deems it appropriate to direct which respondent is authority?
1 to 3.
Huh?
Respondent 1 to 3.
Who is the competent authority? Must be one. The first respondent shall consider the representation of the petitioner, take it.
Plus 28/5/24.
28/5/2024 in accordance with law within a period of 4 weeks from the date of receipt of the copy of the order.
One submission. I may be given times for for next year. For this year, they have renewed my loan. I may be.
No, but the difficulty is.
Because I have paid 4,50,000 for renewal of fees. I have already deposited money. In the annexure also, they have mentioned my loan. 4,50,000 they have collected my loan.
Till when is your license? Till which month of 2025 you are having license?
My lord, it is they have granted 21/6/2024, my lord. Next, my lord, June 2025, my lord.
And the 6 months? 7 months?
They have collected 4,50,000, my lord. And even I have paid till June 2024 rent, my lord. And I have produced the annexure R3 statement of bank statement, my lord.
There seems to be some friction between my client and his client. It appears.
Already half year is over.
Whilst considering my representation, let him be afforded an opportunity that at least he'll get some time before the authorities.
Because Lord's order, they will immediately start vacating by taking the support of police, my lord. At least, my lord, in that 7 months, I will be given. Annexure R3 is the bank statement and annexure R2 is the license renewal.
So, your client is getting his.
Since 20 years, I am running.
No, your client is getting getting the rent.
It appears he is depositing the rent. I'll have to see whether he has accepted because
no, the bank statement is clear, my lord.
That order list is matter on 27th of November. Get instructions.
Please.
After lunch. No signatures. No adjournments now. Huh? 38. Pass over if you are ready. What has happened? Dismissed? Then pass over. What happened to 39? No, that I understand. What happened to 39?
39.
Dismissed. Finally, tomorrow in the same caption. Dismissal caption tomorrow at the request of learned counsel for the petitioner. Yes.
38 also.
Huh?
Serial number 92.
90?
Both the matters you have to submit a declaration of assets and liabilities. And I did read such a letter.
Then why are you not doing it? 2019 matter.
So, when you have the matter next week.
92 and 92.1. Let's just matter on 26 November. No further adjournment.
I have kept a affidavit.
Huh?
Yes, I have kept it.
Yes, next. Huh?
26.
87.
87. Respondent, sir. Ganesh Rai.
Have you informed the counsel for the petitioner? Yes, at the request of learned counsel. When do you want? Huh? Wednesday, next week. Yes, at the request of learned counsel, the respondent is this matter next week. When the court is specifically asking the advocates to make mention at 10:30, everybody is starting at 1:30. Serial number? Huh?
99.
No.
Michael.
Give it to the court officer. Huh? You can't, the first, your request is heard because it is dismissed for default. That's why it's posted today. You please wait. You can wait and then mention before the court.
Sati can put one. Sati can put one.
Needful is done. Where do you get that? At what time?
It takes the 5 minutes.
Where do you get that? Today. Learn counsel the petition submits that the needful is done. Place this matter after service of notice. Next.
Number 20, postponement. Dharwad postponement. 20, Sajid Ahmad. Sajid Ahmad.
Will you ask for a password in the morning?
No, ये नहीं था.
ऐसे ही पासवर्ड नहीं मेरे ख्याल से कोई पूछे
Sajid Ahmad tomorrow. 20.
no representation for dismissal tomorrow.
Number 20.
So you wanted to get some instructions? No, the MC is still pending. Issuance of notice in unclaimed R1. Argue then. The docket order, notice to R1, returned as unclaimed amount stream service of notice. Yes. Use the mic. Yes, where is imputed order?
Imputed order is at page number minutes. At 33 minutes.
Not 33.
33 minutes.
33 is your wakalat. Yes.
There is a nearby director responding to pay interim maintenance of 3,000 per month to petitioner number 1 and 2,000 per month each to petitioner number 2 and 3, total 7,000 including all the petitioners from the date of petition.
What is your income?
But as far as concerned report, the respondent number 2, she is staying with me, minutes. And that this honorable court please to grant the stay also. Stay has been granted of 3/6/2024.
No. Who is staying with you? Respondent number
2 minutes.
Respondent number 2 is daughter.
Yes, ma'am. She is staying with me, minutes. And this honorable court.
So now leaving that 2, then the remaining amount is 5.
Yes, 5 minutes.
It can be allowed.
Yes, ma'am.
Please come. Agreed with the orders passed in I number 2 in criminal miscellaneous number 306 of 2023, whereby the court had granted 3,000 maintenance to the wife and 2,000 each to the children. The husband is before this court. Land counsel appearing for the husband submits that the respondent number
2 minutes.
Respondent number 2 is staying with the petitioner himself. As such, question of paying maintenance to respondent number 2 does not arise. Notice is on the respondents, but it returned as unclaimed, and this court has held it as deemed service of notice. Next one, having heard the land counsel the petition. The maintenance that is granted is 7,000. That is 3,000 to the wife and 2,000 each to the children, which is a bigger amount. But considering the fact that the second respondent is staying along with the petitioner, the order of the trial court, the family court is modified, and this court is passing the following order. The petitioner shall pay maintenance of an amount of rupees 3,000 to the wife and 2,000 to respondent number 1 and respondent number 3.
Yes, sir.
Respondent number 3. Accordingly, the order of the court is modified. Yes, next. Yes.
Yes, Shakar.
Yes.
Husband petition, madam. Because the husband filed a divorce petition, which is allowed, madam.
Mike.
And now the respondent filed a criminal MCN for maintenance, which is allowed for the rupees of 10,000.
How much?
10,000 for respondent number 1, 2, 3.
Mm.
Now we filed for set aside the.
What is your income?
Madam, there is no exact income is mentioned.
Let's see the order. Please come to the order.
She stated that.
Come to the order. Which page? Come to the reasoning part. Para? Read para 17.
Even on the aspect of the quantum of the maintenance also, I have gone through the material on record. So in the evidence, petitioner stated that respondent is engaged in the business with the trade name Procedural engineers. She also stated that respondent engaged in the manufacturing of cement, electrical poles and sale of such electrical poles. She also stated that respondent is also having one business established in the name of his mother, named of such industries, Sudaya Cement Industry. She also stated that the factory is established in the land bearing number 70,000 situated at the Leftingly junction. Stated that her husband getting net annual income is 75 lakh. On this aspect,
so in the other matter, in you have in MC number 31 of 2020, you yourself has admitted that your income is 78 lakhs 96,000.
But there is no evidence, my lord. There is no evidence that proves.
Admitted facts need not be proved. You yourself admit that your income is 78 lakhs. What evidence you require?
But there is no evidence on record.
That's what I'm saying. That's your admission. You're bound by your admission. If you have to say that no, that day it was 78 lakhs 96,000. Right now I don't have any evidence. Now the burden lies on you. Please come. Agreed with orders passed on criminal miscellaneous number 141 of 2021, dated 31st May 2022. The husband is before this court. The respondent wife had filed a petition under section 125 CRPC claiming maintenance of an amount of rupees 30,000 per month. The facts of the case are the marriage was solemnized on 8/4/2012. Out of the wedlock, they are blessed with a daughter, blessed with 2 daughters. And in view of the differences between the parties, the wife is staying along with 2 children. It's a case that she has no income to maintain herself. It is a case of the wife that husband is a licensed class 1 contractor and is having well-established business of installation of electrical lines, poles, transformers, and other electrical instruments, and also engaged in maintenance of electricity power line. He undertakes works from Bescom and also engaged in business mainly in Dharwad district on contract basis since the year 2008. And according to her, income of the husband is 75 lakhs per annum. It is the case of the husband that he engages employees in HESCOM work and is not concerned to maintenance of electricity line. He has to maintain his old age parents, and the wife, without a reasonable cause, left the company of the husband and started to reside in her father's house. And as such, she is not entitled for maintenance. The court, while granting maintenance of an amount of rupees 10,000 to the wife, had observed that in matrimonial case, that is MC number 31 of 2020, the husband has clearly admitted that his net annual income, to the extent annual income is 78 lakhs 96,000, and the court has also reproduced the cross-examination of the husband in MC number 31 of 2020. Saying that it is a work property, then let there be an adjudication on that by the tribunal. The same issue with regard to the maintainability of it, let there be evidence adduced by both the parties. Let the tribunal decide it basing on the material, or instead of doing it in a very slipshod manner.
Of course, in this manner, it should not have been done. To that extent, I can also.
So what we say is, on that, let both of you, whatever evidence you want to adduce it, and within a short time, the court decides it. Let's accept this one. Please come. Where is that straight away, like what application, what procedure?
There was no application filed. Even order 7 to 11 for that matter does not say an application. Says court shall pass an order. Court shall pass an order. Court had not exercised power so much. If it sees that it is barred by law. The previous orders in the order sheet kindly looked into.
You only raised the maintainability issue.
Issue of maintainability.
Agreed by the orders passed by the tribunal dated 28/7/2023. He is called as a petitioner there.
Plaintiff. It's a suit.
Agreed by the orders passed by the tribunal dated 28/7/2023. The plaintiff is before this court. The plaintiff had filed a suit seeking injunction restraining the second defendant from interfering with the possession of the suit scheduled property. It is a case of the plaintiff that it is a notified institution as per the Gazette notification dated 3/2/1972. The suit properties are the Kabristan used for burial of Muslim dead bodies, and they are notified as additional properties of the work by order by Proceedings dated 13/11/2002. It is the grievance of the plaintiff that the second defendant, without any manner of right and title, is interfering, which made the plaintiff to approach the court. The defendants have filed their written statement. The second defendant had filed the written statement, had taken and had raised several issues. One is that the suit is barred for non-joinder of the proper and necessary parties. According to them, he is a protected tenant, and with regard to the issuance of the certificate, the issue is pending before the Land Reforms Tribunal. That application is filed in the year 1974. Once the issue is pending before the Land Reforms Tribunal, question of notifying the properties in the year 2002 will not arise. No, it is granted. Occupancy right is granted.
Granted, the landlord preferred a petition, remanded.
It is
rejected,
stated that,
then again
stated that
second time remanded.
on 19/8/1776, when the tribunal granted occupancy rights, the landlord has stated challenge the same by filing a writ petition, and that came to be allowed. And after fresh inquiry, tribunal rejected form number 7 filed by him and other tenants by order dated 21/1/1986, and the defendant number 2 has challenged the said order by filing WP number 20989 of 1994, which came to be allowed, and the matter was remanded for fresh consideration by order dated 6/11/2016, and the same is for pending consideration. It is the case of the defendant that is in actual possession of the property, and the plaintiff has no right or manner of title to the property. It is the case of the defendant that when the matter is pending adjudication before the Land Reforms Tribunal, the plaintiff cannot come before this court, cannot come before the tribunal and seek injunction. Further, it is the case that they are denying the title of the plaintiff himself. The tribunal, by order impugned, having considered the respective stance taken by both the plaintiff and the defendant number 2, and considering the fact that the issues are pending before the land tribunal, and the court lacks jurisdiction under section 132 of the Act, and the suit is set by order 7, rule 11D of CPC, and accordingly rejected the claim. Next part. When counsel appearing for the petitioner, plaintiff submits that the court considered this as an application under order 6 to 11D. The court, while considering an application, while considering the matter under order 7 to 11D, court can alone look at the plaint but nothing else. But unfortunately, in this case, court had considered the allegations that are made in the written statement, and basing on that, court has come to the conclusion that the suit is not maintainable and rejected the plaint. He submits that the court ought not have conducted such an inquiry. As such, the order included is liable to be set aside. Next paragraph. Learned counsel appearing for the respondent defendant number 2 submits that it is settled law that when the proceedings are pending before the Land Reforms Tribunal, the court lacks jurisdiction, the tribunal lacks jurisdiction. Section 132 of the Act. And there is no dispute about the fact that the proceedings are pending before the Land Reforms Tribunal. Land Council submits that. These two things makes it very clear that the suit is not maintainable before the tribunal. If at all the petitioner, plaintiff had any grievance, they ought to have approached the Land Reforms Tribunal. The court had rightly dismissed the application and rightly rejected the plaint, and no grounds are made out seeking interference with the order passed by the tribunal. Next paragraph. Having heard the land counsels, he relied on the respondent. He relied on the judgment of the apex court in case of R. Ravindra Reddy and others versus H. Ramaya Reddy and others, reported in AR 2010 Supreme Court 991. It's for having heard the counsels on either side. Where is the material on record? According to the plaintiff, is a registered Waqf as per the Waqf Act, and the suit scheduled properties are notified as the properties of the Waqf by the government in the year 2002. According to the defendant number 2, he is a protected tenant, and for the issuance of the occupancy rights, the proceedings are going on right from the year 1972 or 1974, and once the occupancy certificate is granted, then thereafter it was litigated by the by the landlord. Thereafter, again, another round of litigation by the tenant. And as of now, the same is pending consideration before the court. The case of the plaintiff is in possession of the property, and according to the defendant, he is in possession of the property. Now, the court, without giving opportunity to the parties to place all the relevant material and evidence before the court, and just basing on averments in the written statement, who ought not to have rejected the plaintiff. The plaintiff cannot be rejected, ought not to have rejected the plaintiff. That too in this factual matrix, where at one stage the defendant says that unless and until the occupancy certificate is issued, the property vests with the government. On the other hand, the very government, about the Waqf department, issues a GO saying that the particular suit scheduled property is a property of the Waqf. In these factual matrix, unless and until the evidence is latent, at the threshold, there cannot be an order rejecting the plaintiff. Hence, in view of the above discussion, this court deems it appropriate to set aside the order reviewed and direct the tribunal to give opportunity to both the parties to leave their respective evidence and dispose of the matter within a period of 6 months from the date of receipt of the copy of the order.
Please.
Yes. Yes, next.
Petition allowed.
Huh?
Disposal allowed.
Set aside and remanded. Allowed.
Allowed.
Yes, next.
Number 66.
66. You are saying something in the morning.
Yes, my lord. I was present, my lord.
Yes, he was not there.
Yes. The number, my lord, the respondent has also filed one more petition.
That's what you said. What is that number?
Furnishing of number.
1001.
Give the number. Tomorrow,
No, next week, any day.
post along with so and so on 13th of November.
One more development, my lord. The petitioner husband, it appears, my lord, they have spoken each other, though it was failed in mediation. Some result may come out, my lord.
Yes. Next. Give that number, write on a paper and give.
79 is the number.
Yes.
Petition. Application under section 293 and then section 45 for request for DNA test of daughter of my lord wife that has been rejected.
Where is the counsel for the respondent?
My lord, I have no merits of case. Your Lordship, I have sent it.
No, this is the one.
Yes. Your Lordship, I kindly send to my lord 13. In the my lord, it can be disposed of.
Yes.
Each page, my lord, 38. In case 38, para 13, respondent registered the claim of petitioner by presenting his contested objection petition, wherein it is categorically denied that the petitioner is illegally wedded wife. It is also contended the petitioner is the daughter of his father's sister. It is also contended his marriage engagement ceremony was performed with petitioner Fakirova, but thereafter respondent came to know that Fakirova is having illicit relationship with another man. Thus marriage was not performed. It is contended his marriage with the petitioner was not performed. It is also his contention that already he has got married with another woman, through whom he has got children, which case of the petitioner Fakirova cannot claim maintenance. Thereafter, parties have led their evidence. Of course, it would be premature to record my finding on the evidence, but this interest application is to be decided on merit. Of course, I am going through the principles laid down in the above dictums. There is no any bar as such for order of DNA test even in the matrimonial cases. But here the facts of the case are all different altogether different.
It is not in dispute that Lalita Parmamma is the daughter of original petitioner Patirava. It is also not in dispute that already Lalita has got married and she is residing with her husband. Further said Lalita Paramma neither party to the original petitioner nor she led her evidence in this petition on behalf of her mother Patirava. Had Lalita Paramma leaving her evidence in this petition, then there is a justification for.
Between the disputes between both of you, a third party
Yes,
who is
third party, our daughter
who's
who has
married.
married and decided.
Please come. Agreed with the orders passed in I number 3 in criminal miscellaneous number 5 of 2019 dated 16th March 2022. Husband is before this court. He has filed an application under section 293 of the CRPC read with 45 of Indian Evidence Act, praying the court to direct the petitioner's daughter, the wife's daughter, to undergo DNA test in order to find out the paternity. According to him, the petitioner is not the wife. That according to him, she is not his wife. She is the daughter of his father's sister. To that, the objections were filed by the wife. The court, by order impugned, had dismissed the application, observing that already the daughter of the daughter is married. She's residing with her husband, and she is not a party to the original petition, nor she read her evidence in this petition on behalf of the mother. Had the daughter is reading evidence in this petition, then there is justification for the applicant, husband, that she has to undergo DNA test. The court came to the conclusion that as a daughter of the original petitioner is not a party to this application. Is not a party to the main proceedings, and considering the fact that she is already married and living with her husband, the DNA test is not required, and accordingly dismiss the petition. Next para. Learned counsel appearing for the petitioner submits that when the deciding the paternity of the daughter is very much crucial for these proceedings, and the court ought to have allowed the application. Just because the wife is not the daughter is not a party to the proceedings, that cannot be a ground to dismiss the petition. He submits that the order of the court is contrary to the settled law. Next one. Learned counsel for the respondent submits that the court, concerning all the relevant aspects, has rightly dismissed the petition and no grounds are made on seeking interference with the order passed by the court. Next. Having heard the counsels on either side, there is a petition on record. There is no dispute about the fact that for the MC, both the wife and the husband are the parties. The daughter is married and living with the husband, and in the proceedings, no evidence is let in on behalf of the daughter. And now that the court had rightly considered the fact that if this application is allowed, it is nothing but violation of the personal liberty of the daughter. And the paternity of of the girl is not the fact in issue. Considering all that, the court had rightly dismissed the application, and this court finds no reasons to interfere. Accordingly, the petition is dismissed. Next.
Number 82.1.
In the morning it is passed forward because I submitted that he is resigned from the job. He also passed.
When he resigned?
Yes. The page 26 note I have stated. January 2021.
46.
Page 26. In the objections to the name petition, these against the impute order is challenging the awarding the interim maintenance of rupees 10,000 rupees. She is not a.
During July 2019, the respondent came to India.
Yes.
Where do you say about leaving the job? That is in January 2021.
Yes.
When is this MC filed? Criminal miscellaneous is filed.
This is after resign.
After 2021.
Yes.
Now please come to the order.
Please file.
Now in that case, where is the evidence with regard to his income?
My lord, in order to get to know the hard realities that the issues are involved in this case, the lordship can the relevant court records. And
He has a copy of it.
No, I don't have information.
Let him also have a copy of it.
yes,
Give it to him. This is started tomorrow. Tomorrow.
please.
At the request of non-counsel for the respondent. Yes, next.
Much.
Number 86.
Judgment debtors are vendors. They sold the property in the year. In the year 1974.
Now, what is the order in view?
My lord, thereafter I instituted suit. My lord, the OS 104 was 74.
No. Impute order is?
Impute order is that my execution petition for protection to implement the injunction order granted decree command has been rejected.
You sought for police protection.
Please.
When is the decree? Decree, when is the decree?
Depends on my possession.
When is that?
1974.